Yes. Yes. Please go. I've formulated a short note also, if I can circulate. Yes, sir. Before just coming to the reference questions, I would like to first say about the object which was behind introducing Section 319. The object was, it was introduced in order to cure some mischief which has been committed by either the investigating agency or some witness during the trial. So this power was introduced and given to the court so that the real culprit or the person who seems to be a culprit who has committed some offense may not go scot-free. Now, my lord, this is a enabling provision which should be construed liberally. And my lord, technicalities which are handmade, my lord, my submission will be they should not, my lord, allow a person who is apparently an accused who can be tried along with the other and seems to have committed an offense to go scot-free. Now, my lord, the court cannot be a mute spectator to all this, that somebody who seems to be an accused who has committed the offense and can be tried with the other accused should be go scot-free only because some irregularity or some decision of the case of 319 application was decided either simultaneously or on the same day because of maybe delay on some technicalities. The application was decided later on, maybe on the same day, that is the reference. So if the case is decided, the application is decided on the same day, but it was moved earlier, and the court had opportunity of looking at the facts from where the court could come to the conclusion that this person is also one of the accused who are being tried. He can also be tried along with them and can also be an accused in the case. He should also be tried and his trial should also be there. Now, this is a new law, and I'll refer to Hardeep Singh's judgment, wherein this object was also taken care of. With my submission, I'll refer to Hardeep Singh's judgment, page 21. Mr. Raju's compilation, we are all using. 112 page of Hardeep Singh's judgment, page 21 of the compilation, para 8. Yes. The constitutional para 8, the constitutional mandate under Article 20 and 21 of the Constitution of India provides a protective umbrella for smooth administration of justice, making adequate provisions to ensure a fair and efficacious trial so that accused does not get prejudiced after the law has been put into motion to try him for the offense. But at the same time, also gives equal protection to the victims and to society at large to ensure that the guilty does not get away from the clutches of law. For the empowerment of courts to ensure that the criminal administration of justice works properly, the law was appropriately codified and modified by the legislature under CRPC, indicating as to how the courts should proceed in order to ultimately find out the truth as to so that an innocent does not get punished, but at the same time, this is important, but at the same time the guilty are brought to book under the law. It is these ideals, as enshrined under the Constitution and our laws, that have led to several decisions whereby innovating methods and progressive tools have been forged to find out the real truth and to ensure that the guilty does not go unpunished. Now, at para 9, the presumption of innocence is the general law of land, as every man is presumed to be innocent unless proven to be guilty. Alternatively, certain statutory presumptions in relation to certain class of offences have been raised against the accused, whereby the presumption of guilt prevails till the accused discharges his burden upon an onus being cast upon him under the law to prove him to be innocent. These competing theories have been kept in mind by the legislature. The entire effort, therefore, is not to allow the real perpetrator of an offence to get away unpunished. This is also a part of fair trial And in our opinion, in order to achieve this very end, that the legislature thought of incorporating provisions of Section 319 CRPC. It is with the said objective in mind that a constructive and purposive interpretation should be adopted that advances the cause of justice and does not dilute the intention of the statute conferring powers on the court to carry out the above mentioned award, object, and purpose to try the person to satisfaction of the court as an accomplice in the commission of the offense that is subject matter of the trial. So, the important is that it should not be the cause of justice should be taken care of, and then it should not dilute the intention of the statute. Now, para 10, in order to answer the aforesaid question posed, it will be appropriate to refer section 351 of CRPC in old code. Now, this is the Law Commission's recommendations which were read yesterday. These recommendations also tell about the object of 319, that the person who seems to be the real culprit, or a culprit in an offense which has been committed, should not go scot-free. For that, the Law Commission also recommended that it should be amended in such a way that they should not go scot-free. I can read these two, otherwise it was read by my learned senior counsel on the other side. I can read two. It happens 24.8. It happens sometimes, though not very often, that a magistrate hearing a case against certain accused finds from the evidence that some person other than the accused before him is also concerned in that very offense or is connected offense. It is only proper that the magistrate should have power to call and join him in the proceedings. Section 351 provides for such a situation, but only if that person happens to be attending the court. He can then be detained and proceeded against. There is no express provision in 351 for summoning such a person if he is not present in court. Such a provision would make 351 fairly comprehensive, and we think it proper to expressly provide in that situation. Then 24.81, how the cognizance is to be taken. It is 190 is explained, and then it is said that it does not make any difference. It will start from that stage. Now, kindly have para 12, page 23. Section 391 CRPC, para, sorry, 319, para 12, section 319 CRPC.
Yes.
Springs out the doctrine of judex tamentur cum nocens absolvit. Judge is condemned when guilty is acquitted. And this doctrine must be a beacon light while explaining the ambit and the spirit underlying the enactment of section 319 CRPC. This is very important. The question will be as to why the enactment of 319 was there.
Yes.
13, it is the duty of the court.
Only difference is that in earlier 351,
Please.
a person will be proceeded only present before the court.
Yes, yes.
The addition that is now, even if a person is not before the court, he can be
summoned.
Brought to the trial.
Yes, that is the only difference. But 351 and 319, they are the same section.
Basically, you are relying on mischief or Heden's rule.
Yes, yes. 319, because if he is not present, then there was a lacuna. So he couldn't be. Now it is said that he can be summoned and then tried. And then 190 is explained regarding the cognizance. Now, then 12, I read 12 to explain only that the ambit and the spirit underlying the statute of and enacting 319.
Of a crime should not go scot-free.
Grateful. Because 351, the word used were detention of offender attending court. So that was a technical hitch which the real culprits used to use and go scot-free. That is why, my lord, now it has been changed and persons appearing to be guilty of offence. So, my lord, now 319 says if a person appearing to be guilty of an offence, even if not before the court. So, my lord, I am saying that the object, my lord, behind introducing 319 is that the person who appears to be guilty should not go scot-free, only on the technicalities. That is why, my lord, amendment, a few lines added, so that they were trying to, my lord, avoid the law by making this technicality, using this technicality, and the real culprits used to escape the law. That is why, my lord, kindly have para 13 also of this judgment. It is the duty of the court to do justice by punishing the real culprit, where the investigating agency for any reason does not array one of the real culprits as an accused, the court is not powerless. In calling the said accused to face trial, the question remains under what circumstances, at what stage would the court exercise its power as contemplated in section 319 CRPC. So, my lord, I have read this just to say that by mere technicalities, I'll come to the, my lord, reference also. The person whom the court finds to be a person who might have committed the offence and needs to be summoned and tried with the other accused cannot go scot-free only by saying that there is some ambiguity and the timing of the passing of the order in the application under 319. Now, my lord, it will defeat the entire my lord, intention of the statute. The intention is that the culprits.
Advocate General, after discussing all these aspects, finally Hardeep Singh came to a conclusion that once the judgment is pronounced,
My lord, that is why.
after explaining the
My lord, I will explain that
background,
also.
everything,
My
you know.
lord, I will explain also with
Para
my,
47.
my lord, with my lord's permission. I am saying,
Yeah.
my lord, Hardeep Singh never visualized the fact that it is on the same day. That is why, my lord, the reference.
Because from what you are reading, why is not in doubt? How is the question?
Yes, my lord, I will come to that also. My lord, I am just trying to show to the honorable court that what was the intention and the object to introduce 319. Now, my lord, Hardeep Singh never visualized this situation that if it is on the same day. I'll come to that also. I am, my lord, only on the object to show that if it is on the same day, what will be the effect? Will, my lords, allow the person whom the court seems to be, my lord, feels is a culprit who should be tried, should go scot-free only because the judgment and the application is decided either simultaneously or one after the other. That is why I am referring to the object. If, my lord, feel the object will be defeated by, my lord, this mere technicality of application being decided immediately after the judgment or simultaneously, then, my lord, the entire statute, the intention behind that will be defeated. So that is why I am referring to the object.
But conviction can't be on moral grounds, no?
It cannot be, my lord. My lord, it is to cure the mischief. Now, my lord, I'll give an example. My lord, I tried yesterday also. My lord, if the complainant says that A is the person who has committed the offence, the investigating agency finds B and C, they will bring them to the court. B and C are being tried, who are not, according to the complainant, the persons who have committed the offence. Now, my lord, application is moved by the complainant when he gives an evidence that he is the person, A is the person who has committed the offence. Now, my lord, by the time the judgment is pronounced, and, my lord, on the same day, application 319 is also allowed, and A is summoned. Well, my respectful submission is, and I put a question to myself, will, my lords, allow A to go scot-free only because the investigating agency played a mischief? Investigating agency allowed the A to escape from the clutches of law by making B and C accused. The complainant never supported.
If the complainant is examined
Please, bro.
and in the examination in chief itself, he points about the culpability of A,
Please.
then would it not be that proper stage to take action under 319?
Yes, Lord, yes, Lord, yes. I am only on the decision of 319. Lord, I am only on the
We
decision
are
of
talking
9.
about- So if from the evidence of the complainant itself,
Please.
it is known that A is also culpable, then should the trial judge wait for a conclusion of the trial?
Lord, he will not. What happened in the present case, Lord, I'll
I am
come.
only giving
Well, he will not.
And about the example which you have given.
Well, I am on the point. Well, if the court decides on the same day, well, because this also Hardeep Singh never visualized. I am only visualizing if well, this is so. I say well, even 1 out of 100. But my respectful submission is even 1 out of 100 if he is allowed to go scot-free like this. This situation may also arise sometimes where, like in the present case, the Honorable High Court had ordered the trial to be expedited. I'll come to the facts of the case. But it may also come sometimes. It may be visualized also that this may also happen. The question will be whether this ambiguity only will allow this man to go scot-free. That is why I was referring to the object. Kindly have this judgment, Manjeet Singh judgment, page 152. Page 152 of the compilation.
Yes.
This is judgment of Manjeet Singh, where Hardeep Singh was followed.
What page?
This is page 152.
150.
152 of the compilation, para 34 of the judgment.
Para?
Para 34,
Yes, we have.
the ratio.
Yes.
Page 152, para 34.
Yes.
Yes.
Yes, we have.
The ratio of the aforesaid decisions on the scope and ambit of powers of court under 319 CRPC can be summarized as under. That while exercising the powers under 319 and to summon the person not charge sheeted, the entire effort is not to allow the real perpetrators of an offence to go away unpunished. For empowerment of the courts to ensure that criminal investigation of the justice works properly. The law has been properly codified and modified by the legislature under the CRPC, indicating as to how the court should proceed to ultimately find out the truth, so that the innocent does not get punished, but at the same time the guilty are brought to book under the law. To discharge duty of the court to find out the real truth and to ensure that the guilty does not go unpunished. Where the investigating agency, for any reasons, does not array one of the real culprits as an accused, the court is not powerless in calling and the said accused to face trial. Section 319 CRPC allows the court to proceed against any person who is not an accused in a case before it. The court is the sole repository of justice and duty is cast upon it to uphold the rule of law, and therefore it will be inappropriate to deny the existence of such powers with the court in our criminal justice system, where it is not uncommon that the real accused at times get away by manipulating the investigating or the prosecuting agency. Section 319 CRPC is an enabling provision empowering the court to take appropriate steps for proceeding against any person not being an accused for also having committed the offence under the trial. Now, this, then 319(1), which I read, then regarding the fact that it is mischief, then how the procedure. Now, with mild permission, I'll read 319 again because that is the under reference. Lord. Lord, 3191.
Yes, we have.
Lord, 3191. It was read many times, Lord. I also read yesterday. Lord, it is the first is 319.1 to identify and to see who is the person who can be summoned. So, Lord, where in the course of an inquiry and offence, it appears that from the evidence that any person not being the accused has committed any offence for which such person could be tried, together with the accused, the court may proceed against such person for the offence which he appears to have committed. So this is, I said, Lord, yesterday also, to identify as to who is the person who can also be tried with the persons who are being tried by the
no
court.
difficulty. The question is at what stage
Lord, I'll come.
a power can be
I'll come to that.
exercised.
Lord. Now, Lord, 4. I am on the procedure, Lord. 4. Because, Lord, the argument raised
How
was,
do you ignore the words in the course of any inquiry into
please,
or trial?
kindly, Lord, then
That-
in an offence.
So we fully agree
Please,
that the source to exercise the power is under 1
please,
and 4 is procedure.
please.
If the source is under 1, then 1 itself specifies the stage at which such a power can be exercised.
Lord, it is Lord, during trial. I'll come to para 47 of Hardeep Singh Lord, after this, because the argument raised, and of course, yesterday Lord, I had argument raised was that a person Lord, who is summoned like this should be tried with the other accused only. That was the argument raised. That is why I am raising, Lord, I am coming to 319.4 by saying that 319.4, the trial of this person has to start de novo. The evidence has to be recorded. It is from the very first stage that the trial will start. So, Lord, that argument that it should be this person who is summoned should be tried only along with the other accused does not hold good ground.
No, I think
That
they said the court will have to apply its mind whether he should be tried separately or
Milord,
together.
Milord,
Thereafter,
Milord,
take a decision.
Milord, I said, Milord, this was Mr. Patwalia's argument. Of course,
They did not
thereafter,
say
Milord,
every case,
it was changed. But this was the argument raised.
you have to only take into consideration the changed argument.
All right, Milord, I'll come to that. I'm so grateful. I thought, Milord, I should.
Post amendment position.
Milord, I thought I should hammer on the position which is in my favor. So, Milord, I tried that. 319.4, Milord, so he can be tried, Milord, de novo from the very, Milord, from the stage at which the other accused were.
That Mr. Nagpur also agreed. Mr. Nagpur said that
Yes.
part will have to be taken by
And
the trial court because at that time it may be in the interest of prosecution that a joint trial would be in the interest
The
of.
question will be, Milord, at what stage this decision has to be taken? I'll refer to that.
The question is at what stage the power given under subsection 1 has to be exercised.
Milord, I'll come to that. Now, Milord, as far as 319.1 is concerned, Milord, this is the reference, Milord, that when it can be done. First reference, Milord, first question I'll try to answer, that the trial court has power under 319 for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of the conviction rendered on the same date before the pronouncing of the summoning order. Milord, I read the object and, Milord, scope and the intention behind 319. Now, Milord, this situation was never visualized by Hardeep Singh also. So they, in para
Forget about Hardeep. The first principle of interpretation is plain and literal. So just try to focus on this word in course of any inquiry into or trial. What is the scope of this?
Milord, I'll come to that, Milord. Because the question will be, Milord, whether it can be on the same day when the judgment is passed, or it has to be earlier to the judgment passed. That is the only ambiguity in the present case.
The question would be what would be any inquiry into or trial.
Yes, Milord, trial will end by the judgment, Milord, being pronounced, being delivered.
That you also agree.
Yes,
Trial will conclude after the judgment.
Judgment being delivered. Milord, I'm using word with very cautiously, Milord. Very cautiously, I'm using the word delivered. So when the judgment is delivered, the trial will come to an end. So Milord, and thereafter the court will become functus officio. So question will be, Milord, I said, Milord, the ambiguity in certain cases can be, Milord, of many types. Now, Milord, But with the reference being made, but I have visualized many situations as to what can happen after 319 application is moved. Kindly have my note, page 3. Different situations which may happen and what is the law. The third page.
Yes, sir.
Well, this is answer to question number 1, where I have tried. Kindly have this first situation is where application under 319 CRPC is filed and decided before conclusion termination of the trial. That is before pronouncement of judgment and order of sentence when applicable. And this order of 319 attained finality during the pendency of such trial. When 319 application is moved, it is decided before the conclusion of trial.
No dispute on that.
No, yes, but I'm just visualizing different situation. There's no pendency, no application filed, 319 application final. Then, it is of course legal. This can be done. Second situation, kindly have next page. Where an application under 319 is moved and decided before the conclusion or termination of the trial. That is before pronouncement of judgment and order of sentence when applicable. Thereafter, order under 319 is pending challenge before the higher courts without any stay on the ongoing trial, that is trial of the co-accused. Meanwhile, the trial qua the other accused is concluded and judgment pronounced. Now, where the 319 is moved, allowed before the conclusion of trial, but somebody has gone against the order.
Covered by Shashikant.
That will be covered. I am only on the different situation. That will be covered by Shashikant, wherein the trial of the co-accused has already concluded. So
In this case, the power is exercised during the stage of the trial.
yes, I am only contemplating different situation wherein the court has come across. Now, Shashikant of course refers to that and says yes, the trial of this person will go on de novo without having any effect of the fact that the co-accused trial has already concluded. So that will be the second situation. Third is the present situation, where it is said when application of 319 is decided simultaneously on the same day, when trial is concluded, the judgment pronounced and the order of sentence passed. In such a scenario, till the conclusion of trial, the learned court does not become functus officio. This is what is to be brought to the notice of the court. If the court becomes functus officio and the application is decided thereafter, then the effect will be different. But if it does not become functus officio, the court still has the file with it.
Special effects.
They're coming for Punjab.
Special effects.
Special effect of situation number 3.
That is the main situation that we have been harping for the last 3 days, but coming to it only in the end.
All right. Yep. Yes. Yes, sir.
Now, it is on the last day, it is said on the last day when both are decided, that is the judgment is also pronounced on the same day and the application is also decided on the same day. Now, in that also there can be situations. One, that there is no clarity as to which order was passed before and which was passed earlier, which was passed later. So, there may be ambiguity in that also, since the reference is there. I am just trying to assist on that. There may be ambiguity in that the court is not clear. It is not coming forth before this honorable court as to which order was passed earlier and which was passed later. Then, I will say under 354, it is only an irregularity. Kindly have section 354. Sorry, 465. I'm sorry, 465. 465 CRPC.
Yes, sir. 465.
465.
Yes.
Subject to provisions herein before contain no findings, sentence, or order passed by court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the complaints, summons, warrant, proclamation, order, judgment, or other proceedings before or during trial, or in any inquiry or other proceeding under this code, or any error or irregularity in any sanction for a prosecution, unless the opinion of that court, a failure of justice, in fact, has occasioned thereby. Now, my lord, the situation I am just contemplating, and in the present case also, my lord, herein, my lord, I referred the order summoning 319 order, my lord, says that the conviction, the court has convicted the other co-accused. Now, court does not mention about the sentence. For that, I referred, but I can refer to the order wherein 319 minute summoning was allowed. In that, the court has specifically said, I can read with my lord's permission,
Page 130
page 130 minute
of the SLP.
of the SLP. But this is page 130. Kindly have fourth line, second unnumbered paragraph. So this is
Yes, we have 130.
as the things stand out.
Yes, we have. Just one second. Yes.
As these things stand out, this FIR number 35 was registered and challan against 10 accused was presented by mentioning that after investigation, well, this is important, after investigation, the challan against the remaining accused will also be filed. But till date, no challan is presented against other accused whose names are being mentioned in the application of 319 CRPC, void by separate judgment. All the accused against whom the challan was presented, except one, are convicted today. So, what I read it again, whose names are mentioned in application of 319 CRPC, now at full stop, void by separate judgment, all the accused whom the challan was presented, except one, are convicted today. The proceedings of this application were separated from the main case. Now, the court mentions here they are convicted today. So, court does not mention about the sentence, because the question of sentence was taken later on. Now, my lord, kindly have 354.
Can you say with certainty?
Yes, my lord. If it is not certain,
Not
even
only
then
on-
I have a case, my lord.
Whether as a matter of fact, it has happened in the same sequence that first conviction, then 319 and then sentence.
My lord, otherwise,
No, not on conjecture and surmises.
no, my lord.
Matter of fact.
My lord, I'll be on facts. Otherwise, the court would have mentioned in the order that wide judgment I have convicted and sentenced those persons. Definitely, they would have mentioned. My friend was arguing, my lord, case of state of UP, in which it was clearly mentioned, convicted and sentenced, and then application thereafter. If there's some ambiguity,
But then
irregularity,
Roznama would show that
please, my lord.
if it has happened in that sequence, I don't know what is called, we call it Roznama in Maharashtra.
Zimni orders, my lord. Zimni orders.
On my turn, I will clarify. It's very, very clear in the Zimni order. Crystal clear.
No, what would have been the position if it was a case of acquittal? No further sentencing,
One
nothing.
is the
Then, my lord, they would have been
The
acquitted.
matter ends at acquittal.
So one
Yes,
is
my lord, they would have been acquitted even before 313 or acquitted thereafter, functus officio. Then I had no case.
So therefore, there must be only one correct position, firm
Please.
position.
Please.
It can't be that the court does not become functus officio if it is an order of conviction, and it becomes functus officio if it is an order of acquittal. Because sentencing is only a consequential order after conviction.
But I'll read 350.
There must be a firm position.
Which is the provision for sentencing?
My lord, 354, my lord, may kindly read. My lord, the sentence will be the part of the judgment, only then it is delivered. 354, kindly read, my lord. 354.
Consequential.
Yeah.
354. shall specify the offence for of which the section of IPC or other law under which the accused is convicted and the punishment to which he is sentenced. The judgment will be complete only when the sentence is also mentioned. It will not be complete. So, para 47 of Hardeep Singh's judgment furthers my case that pronouncement of judgment and the delivery amounts to conclusion that the 319 cannot be used after the sentence functus officio, I said, in case of acquittal, as soon as the judgment is pronounced, because no question of sentence in that case. But in case of conviction, the accused have to be given opportunity to be heard before the passing of sentence. Then 354C, wherein the judgment will be complete only when the order of sentence is passed. Now they are relying upon only this paragraph of the order of 319, that this was passed earlier, conviction order was passed earlier, and 319 order was passed later on. That is the only line they are relying upon. That is why I am also on that line. Otherwise, they don't have anything to say that this judgment was pronounced earlier and the order under 319 was passed later on. They say, because it is mentioned in the order itself that the persons have been convicted, the judgment has been passed of conviction. I say, all right, conviction is there, but then the sentence is passed thereafter. Otherwise, the court would not have missed that part, saying that convicted and sentenced. Even otherwise also, I say where this honorable court has slightest of doubt regarding the fact as to which was earlier and which was later, I can say it is simultaneous. If it is simultaneous, it is irregularity. The culprit cannot be allowed to go scot-free only because the court either pronounced one of the applications, order in the one of the applications later, and then the sentence thereafter, or pronounced it on the same day. Well, the entire object of 319 I read is so that the person who the court seems to be an accused who has to be tried along with the other will go scot-free by this mere technicality as to when this was pronounced. But by Mr. Nagamoto also yesterday, it is only when the sentence is pronounced then the the judgment is complete. And
Maybe to that extent you appear to be right, Mr.
I'm
Advocate.
so grateful, but I am right somewhere. But I'm so grateful. I'm just trying that, but I'm just trying that. So, but then, but if
You appear to be right. We have not said we are right.
that is what but under 319, it appears that he is accused because he will come. He is not convicted. He will be tried by the court and let off. But only one thing, if my let's kindly permit me here. But if this is allowed, complaint doesn't have
Anyway,
any.
we are not answering on facts. We are only declaring the law,
Yes,
leaving it.
yes, Milord, yes.
It's your headache there.
But I am contemplating only the situations that on the same day, if the situation is that the conviction is there but sentence is thereafter, on the same day the sentence and the conviction is first, then the order. On the same day, Milord, there is something else that it is simultaneous. So, Milord, it is I am trying
But
to
we must
answer.
also keep in mind,
Please.
in a case where in the cross-examination he concedes and you, in a case, not in this case, you manufacture a witness, make an application under 311, ask him to bluff something and issue 319.
Milord, two situations in that. That is the court which has to see whether 311 will be allowed. Then they have a remedy to challenge 311, which has not been done in the present case. That attained finality. They could have done at that time. Now, Milord, coming here and the investigating agency try to shield them rather than Milord, be against them. The initial challan presented saying that other accused, the challan will be presented. It was never presented. The witnesses are summoned, Milord, 3 of them. I have not referred to the case at all. There are SIM cards belonging to Pakistan.
All right, you come on the
Milord, lot of arms recovered.
We are not answering any
Milord,
question of fact.
Milord, yes, I said, Milord, lot of SIMs, calls, Milord, heroin, arms, different arms recovered in the present case if we come to the offense committed.
All right,
The
you.
question will be a lot of cash also.
That will arise only when.
Yes,
it is
Milord, in fact,
examined as to whether
since-
the witness is.
Yes, since Milord, it was argued,
This stage it does.
since it was argued that he belonged to a premier family and now this has happened, I am only saying that this is what the offense is. And Milord, the complaint has no remedy thereafter. But if accused is summoned under 319, he has remedies of higher courts. Kindly, Milord, visualize that situation also. If complainant moves an application and it is not decided or decided on the same day, he has no remedy. Whereas the accused is summoned only. He is not convicted. He seems to or appears to be an accused who is to be tried, and then the court will come to a conclusion whether he has committed the offense. He has a lot of rights thereafter, remedies thereafter, but the complainant and the prosecuting agency doesn't have.
All right, all right.
Because of Milord, the technicalities and irregularities. Now, Milord, that is why I was reading 465. If this is the situation,
Yes, 465.
465,
Yes.
subject to the provisions herein before, contained no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission. Well, I'll say this is error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceeding before or during a trial, or in inquiry or other proceeding under this code, or any error or irregularity in any sanction for the prosecution. Well, this is important now. Unless in the opinion of that court, a failure of justice has in fact occasioned thereby. The court has to come to the conclusion that there is a failure of justice in determining whether an error, omission, or irregularity in any proceeding under this code or any error or irregularity in any sanction for the prosecution has occasioned a failure of justice, the court shall have regard to the fact whether the objection could or should have been raised at an earlier stage in the proceedings. So, my submission will be, as far as this case is concerned, it is squarely covered by 465. At the most, it can be said to be an omission or irregularity on the part of the learned court, either pronouncing it after the conviction or pronouncing it before that. And it is on the same day. Kindly appreciate simultaneously on the same day. So if it is on simultaneously on the same day, an omission or error or irregularity committed by the court, the accused cannot take benefit of that. The accused cannot go scot-free. But I said if the court pronounces it after that, there is no remedy left with the complaint or prosecution. 319 will not be allowed if it is on the same day. Also, what I said, many situations, if it is pronounced on the same day. Now, here is a case where 319 application was segregated. So, there's third situation in the present case. 319 application was segregated because there was a stay by the Honorable High
Is
Court.
there any statutory definition for judgment here in the
Yes.
CRPC?
Yes, 353, 353 and then 354.
No, no, definition of judgment, like you have in CPC.
No,
there is
You don't have.
what interpretation of 353?
So 350,
Yes.
350.
What would constitute and then language of the judgment is not.
Judgment says what judgment.
Because in CPC you have a definition.
Yes.
My friend has referred to another judgment where, of course, it was also referred
Yaqub
to.
Menon, your lordship have said what a judgment is at para 106.
It includes the
It
sentence
includes
also.
sentencing because 353 is direct, 354.
Which is that? Which is that?
Where is?
Because Yaqub Menon is below
Bombay
2013.
Blast case, it was that when is it to be handed over? Because in the Bombay Blast case, what happened, Yaqub Menon, he pronounced conviction and then posted it for sentencing much later. In the meantime, they asked them to surrender and go into custody. That part of the order was challenged.
Yes.
And therefore,
But
your
that
lordship
you-
said that you can't ask them to go into custody till you actually supply them a full copy of the judgments, and that can only be supplied to them post conviction. That's
Thereafter, he should be heard.
correct. He can. So that's a totally different. Yaqub
No,
Menon is
the question, the moot question remains, what is the judgment? Judgment includes the sentence. That is what is mentioned in the judgment, in the Yaqub Menon's case also.
All right, you can.
I'll pass on.
your turn.
That's the learned.
All right, all right.
So, I have. So, I am on the judgment and the order being pronounced on the same day. Well, there is ambiguity, and the honorable court is not able to come to the conclusion as which order is the first order and which is the later. Then, as an officer of the court, my submission will be the person cannot be allowed to take benefit of that. It's a case, where 319 is enabling provision, given power to the court to summon a person, and he will go scot-free only because there's some irregularity or ambiguity in the pronouncement of the order and the judgment.
All right, sir. All right.
He has remedy after being summoned. This I'm again saying the remedy is with the accused thereafter. But as far as the prosecution is concerned or the complaint is concerned, they don't have any remedy thereafter. So if the court pronounces it on the same day, it should be taken as simultaneously, not one after the other.
All right, sir. All right.
And then in the present case, I said another ambiguity that the case was segregated, separated. 319 application was separated in the present case. So it was being dealt with separately. So although the dates are same, I've checked the Zimni orders. The dates of both the
Then the
application,
question would be whether it can be considered separately.
segregated in a case, what happens is, there's an order also here. If 319 is allowed, then the main file is tied and the new session case number is given. Like in the bail application and other applications, it's a separate application. And it was never challenged. It was segregated only because of an order by the Honorable High Court. It was segregated so that the other persons who are facing trial are not prejudiced by that fact.
No, no. The contention was segregation cannot be made because it is based on the evidence you take a decision. So if this in sessions case is there and that evidence is there, only then you can think of allowing the application or not allowing the application. So it can't be a standalone application.
But if normally what is done is like in bail applications also, other applications also, they are separately numbered, miscellaneous number is given, they are separately numbered. My submission will be,
No, keeping in view the scope of the application.
yes,
It can only be dealt with based on the evidence.
the question will be one, that order was never challenged and attained finality. As far as
That's an
Not a party.
I am only saying, as far as the reference is concerned, if it comes to this conclusion that it was segregated and separated, the facts will be seen by the honorable bench which has referred whether it can be allowed or not. The question will be, I am only contemplating the situations. If there is situation where simultaneous judgment and the order, situation where sentence is passed after the conviction order, sentence where the judgment and they are passed on the same day, and in some cases where there is segregation of 319 applications. So these are the situations I am contemplating. It is such situation, the application, if it is decided separately, although on the same day, the application of mind, I refer to para 40 to 42 of Hardeep Singh's judgment, the court started applying its mind when the application of 319 was moved. So if the court decides on the same day, when it decided the case of the co-accused, it applied this mind while deciding. It was argued yesterday also, if while convicting the persons, the court finds there's something else to be done in the case, it could have done. Functus officio, the court is not at that time, even at the time of sentence also. So even passing the order of conviction, the court would have used power under 311 or 319 also. So if while passing the order, court comes to conclusion, while passing a judgment, that in this case, these persons are also to be summoned, we can't say that 319 is passed thereafter, so it cannot be taken into consideration at all. That will be travesty of justice for the prosecution and the complainant. It is not always that 100 witnesses or more witnesses are examined. It is only one witness examined or two witnesses examined and the application is moved. It may be in some cases which my senior colleague was referring. If 100 are, then of course it has to be at the time of pronouncement of judgment because the trial has almost concluded. So it cannot be before that. And the situation arose in this case also because most of the prosecution witnesses had been examined. And the court decided probably in 2 months. The court decided the application after it was listed along with the trial. And the session case, as already I said, would be numbered thereafter. My submission will be, although it was segregated, even then the court decided simultaneously on the same day and dealt with them on the.
All right, please proceed.
Please.
All right.
Now, the second reference was whether the trial court has power. That was the second question. Whether the trial court has the power under 319 for summoning additional accused when the trial in respect of certain other absconding accused, whose presence is subsequently secured, is ongoing, pending, having been bifurcated from the main trial. So that is the second question which is referred.
Actually, that is not relevant for us here.
My lords have to answer that. For that I say, not maybe for the facts of this case. If 319 application is
Squarely.
Yes. I corroborate to what he said. So we are all on the same page as far as
What
this
Kotawalia said is, if you have a case, make an application there, manufacture a witness and make out a case.
But it is very easy to say, sometimes the witnesses are also influenced. They do not say something in the court, second time they come and say different things. So we cannot at this stage say.
Even the police officers.
Of course. They always say, witnesses, I'm saying. It's as already argued, a premier family. So witnesses never said anything earlier. They said thereafter, even the police officials never filed a challan, never filed a charge.
What is this premier family?
I'm just taking
CRPC. They have a different CRPC.
It seems to be, those persons,
Premier family business.
premier family are never challaned. Premier family witnesses never depose against them. So that is premier family. I can just define that. So if these persons are allowed to go scot-free because 311 application is not challenged, the order is not challenged, the witnesses are.
Learned Advocate General, we are not on the facts of the case.
No, since that question was asked, I only said, the 319 application, if it is moved on the basis of the evidence in the first trial, it will not be. But if 319 application is moved on the evidence in the second case in which the
All right,
absconding
sir, there
accused has
can't be any
surrendered.
dispute on that even
Yes.
otherwise. All right, what is the third question? Come to
Let-
the third question.
Well, as far as the third is concerned, only one submission. Well, a suggestion only, wherein well, the trial of these persons who are summoned subsequently under 319, well, it should be expedited. The well, as far as well, the trials are concerned, and well, one more suggestion: when an application under 319 is moved, the court may be asked to well, expedite the applications first, 319 application, and decide it before the judgment is pronounced. That will well, help the both the sides. So it will be well, only
Such litigations would be avoided.
well, such situation will never come. But it may be, I don't say anything. It may be either side, no fault of the prosecution at all. Prosecution moved the application at the right time.
All right, sir. Now we will hear Raju, sir.
Grateful, so grateful. It was a clear, so grateful.
Come near the mic, Mr. Raju.
Coming, sir.
I will be, I'm for the union as well as for the ED, Manoj. I am only assisting the court on questions of law. I will not go to the facts.
Yes, sir. Very brief, Raju. We have heard now fully.
Manoj, there are some points which I like to.
All right,
There are three essential submissions, Manoj. First submission is this one, which I will elaborate. Is a plain reading of section 319, literal reading of 319 does not contemplate, my lord, as far as when the application of 319 is to be decided, it does not say that it has to be decided during the trial. Only thing it says, the evidence during the trial has to be considered. I'll make this submission good, but I'll have to deal with subsection 4. But subsection 4, I will point out, was enacted only for a limited purpose of taking cognizance. I'll go to my lord, the debates that took place before it was passed, my lord, which clearly says that to overcome a possible lacuna in 190 of the CRPC, that they've done this. That will clear the issue. My lord, nothing to do with, my lord, stage of the. This is my first submission. The second submission is this, my lord. Assuming that there is a second interpretation possible, which according to me is not there, then also the purpose and intent has to be seen. If the purpose and intent is looked at, it cannot be said that, my lords, that the application has to be decided during the trial only. The purpose and intention is to do complete justice, but complete justice includes complete justice, my lord. So if the purpose and intention is to do complete justice, the stage, whether you can't do it till a particular stage and you can do it after a particular stage, would be irrelevant. That is going to be my second submission, my lord. And I'll elaborate on that. The third submission is this. Assuming that my lords hold against my submissions as far as these 2 points are concerned, then in any case, supposing an order is passed, despite a requirement that it can't be passed after the trial, then also the order is not bad. It is only an irregularity, and to set aside that irregular order, there must be pleadings, and those pleadings must.
Mr. Raju, see, we are concerned with only basically on first question of law. What is the first question of law referred to as? Concentrate on that. We are not going to
These are the three
consider all these aspects.
Very well.
The first aspect you rightly started 319.
Yes, but
So
kindly
only on 319 you address your argument.
Very
Not
well.
on other factual aspects.
kindly have a look at 319.
In 465 may not have, for us it may not be applicable 465 to decide this case.
My endeavor is to point out, Manoj, there is some need to go into 465. I'll make it when I come to that, Manoj.
All right,
Kindly have a look at the
start.
first proposition, Manoj.
Yes.
A first proposition, my lords, may kindly have a look at 319, Manoj.
Yes, 319.
where in the course of any inquiry into or trial of an offense, we are concerned with trial, but not with an inquiry, it appears from the evidence that any person not being the accused has committed any offense for which such person could be tried together with the accused, the court may proceed against such person for the offense for which he appears to have committed. Therefore, first requirement is, my lords may kindly have a look, that there must, my lords are having my note, my lord.
Yes.
But first requirement is, kindly have a look at para 5 of my note. Page 2. It's not number. Requirements have said, my lord, it must appear from evidence obtained in the course of any inquiry or trial. At the para 5, my lord, say what?
Yes, we have.
It must appear from evidence obtained in the course of any inquiry or trial. That is the requirement as far as the trial is concerned. Second is that a person not being an accused, that is not being tried in the trial where the evidence has surfaced, appears to have committed any offense.
It can be done at any stage, only from the.
And my lord, the offense which appears, I'm sorry. So kindly have a look, my lord. The words could be tried together. Only indicate, my lord, the type of evidence. So what is the type? It is not that evidence with respect to any offense should surface. It is only that type of offense which could be tried together. So the words could be tried together in section 319, subsection 1, does not indicate that the offense should be tried together, but the evidence, the nature of the evidence should be such that it could be tried together. Pardon, my lord?
That is what Shashikant says.
Yes, but that is what Shashikant said, but this is my submission, my lord. Then, my lord, I know I have to cross the hurdle of subsection
That
4.
is not a question. The question is at what stage the power can be exercised. Whether
Yes,
it
my
can
lord.
be-
I tell my lords how this would be relevant, my lord. The possible contention could be that if the matter is, the offense is to be tried, the matter is to be tried together with the other accused, it can't be pronounced after the trial. Otherwise, this would become OTOs, my lord. My lords may kindly have a look. The submission, possible submission which is not specifically made is, if there is a joint trial, if the 319 contemplates joint trial, and you pronounce the 319 order after the trial, then the purpose of joint trial is frustrated. Therefore, my lord, the purpose of 319 is not joint trial. If the purpose of 319 is not joint trial, then it doesn't matter whether it is before the trial, after the trial. Because it's only when the purpose of 319 is that there should be joint trial, that if you pronounce it after 319, that it becomes, my lord, bad. Otherwise, whether you pronounce it before or after the trial, it makes no difference. Therefore, my lord, otherwise, my lord, the question which I'm asking myself is, what is the need that it should be pronounced before the trial? The only need is, if there's going to be a joint trial, it has to be pronounced before the trial. If it's not going to be a joint trial, it hardly matters whether it is pronounced before the trial or after the trial. Therefore, my lord,
Yes.
now kindly have a look, my lord. Further, my lord, the section does not require joint trial. Section does not contemplate joint trial. What is the law as far as joint trial and separate trial is concerned? There is a latest pronouncement of this court, my lord, this honorable court, where a ladyship was a party to the order judgment, my lord. I'll point that out. Therefore, there is no need of a joint trial, and there can be a separate trial.
You got some authority.
In subsection 4 of.
Yes, my lord. Kindly, therefore, have a look at the proceedings which have annexed, my lord. My lord, sir. Kindly have a look at my volume 2 compilation which I have given today, my lord. And kindly have a look at page 130, my lord. Why 4B was introduced? 130, it starts at 130, my lord, Law Commission report. Why? That has something to do with section 190, which says when a magistrate can take cognizance. You can take a cognizance on a private complaint. You can take a cognizance on a police report. But the issue would arise, can you take cognizance when there's a 319 order? To obviate that issue, 4B was added. Well, that is what the report says. Kindly, therefore, have a look at, my lord, page 132, my lord. Kindly, 131, my lord. 131, bottom, 24.80. Volume 2 of my compilation. My lords have got it?
You have got it.
Same thing I had placed with my companion.
You have read this actually. You have read this. At least twice, thrice we have read this. All right, you read, no problem.
Therefore, kindly have a look. my
You
lord.
may give a new dimension,
Yes,
who knows?
therefore, kindly have a look at it. my
All
lord.
right.
It happens sometimes, though not very often, that a magistrate hearing a case against certain accused finds from the evidence that some person other than the accused before him is also concerned in that very offense or in a connected offense, and it is only proper that the magistrate should have the power to call him and join him in the proceedings. Section 351 provides for such a situation, but only if that person happens to be attending the court. He can then be detained and proceedings against and proceeded against. There is no express provision in section 351 for summoning such a person if he is not present in court. Such a provision would make 351 fairly comprehensive, and we think proper to expressly provide for that situation. That is for then the part that is important, bro, 25.81. Section 351 assumes that the magistrate proceeding under it has the power to take cognizance of the new case. It does not. However, say in what manner cognizance taken by the magistrate. The modes of taking cognizance are mentioned in section 190 and are particularly apparently exhaustive. The question is whether, against the newly added accused, cognizance will be supposed to have been taken on the magistrate's own information under section 191C or only in the manner in which cognizance was first taken of the offense against the other accused. In concrete terms, if the original case was instituted on a police report under section 191B, will cognizance against the new accused be supposed to have been taken in the same manner or under section 191C? The question is important because methods of inquiry and trial in the two cases differ. About the true position under the existing law, there has been difference of opinion, and we think it should be made clear. It seems to us that the main purpose of this particular provision is that the whole case against all known suspects should be proceeded with expeditiously, and convenience requires that cognizance against the newly added accused should be taken in the same manner as against other accused. We therefore propose to recast section 351, making it comprehensive and providing that there will be no difference in the mode of taking cognizance if a new person is added as an accused during the proceedings. It is of course necessary that in such a situation the evidence must be reheard in the presence of the newly added accused. Now kindly have a look at 190 of the CRPC. It is only to clarify that there should not be any difficulty as far as taking of cognizance is concerned. The cognizance order should not be challenged, that 4B was added. My lord, sir, I have 190 minutes. cognizance of offence by magistrate, subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class specially empowered in their behalf under subsection 2 may take cognizance of any offence upon receiving complaint of the facts which constitute such offence, upon a police report of such facts, upon information received from any person other than a police officer or upon his own knowledge that such offence has been committed. The issue would arise whether he is taking cognizance under B because the police report was filed with respect to other accused, or whether he is doing that section 4B was added. Now kindly have a look at 4B, my lord. Now after this report has been looked at, Law Commission report, now kindly have a look at section 319 4B. Where the court proceeds against any person under subsection 1. I'm sorry.
Yes, yeah.
Where the court proceeds against any person under subsection 1, then the proceedings in respect of such person shall be commenced afresh and the witnesses reheard.
319 4B.
3194.
Yes.
Kindly note, my lord, subsection 1 also uses the word proceed and 4A also uses the word proceedings and does not use the word trial, my lord. There's a difference between proceedings and trial. I'll point out that also, my lord. And my lord, so proceedings in respect of such person, not in respect of all persons, as was pointed out by my lords earlier also. So it is only with respect to that person shall be commenced afresh and the witnesses reheard. Then what B? Subject to clause A, the case may proceed as if such person has been an accused person when the court took cognizance of the offence upon which inquiry or trial was commenced. This was inserted only to overcome a lacuna, if any, with respect to the magistrate taking cognizance. That is why it is there. It has nothing to do with, my lord, that as far as trial proceedings are concerned, whether, my lord, as was sought to be interpreted by the other side. It is only to see that an error.
No, we didn't get to what was thought to be interpreted by the other side.
But they said that this should be interpreted to say, my lord, that my kindly have a look, may proceed as if such person has been accused person when therefore this would suggest, my lord, that the new person should be an accused person and there should be a joint trial, meaning thereby that there can't be a judgment, there can't be an order under 319 after, my lord, the pronouncement of the judgment.
That is what the Constitution bench says.
No, my lord, kindly have a look at this. The Constitution bench says, my lord, as far as
the power of order under 319 can be passed at any stage after the charge sheet is filed till pronouncement of judgment.
kindly have a look, my lord, as far as the Constitution bench is concerned, my lord, relevant paras of para 40. 40 is what has been relied upon.
Read 47.
47.
47. First paragraph itself. First sentence, sorry.
Since after filing the charges, the court reaches the stage of inquiry, and as soon as the court frames charges, the trial commences. Therefore, power under 319(1) can be exercised at any time after the charge sheet is filed and before pronouncement of judgment, except during the stage of section 207, 208, committal, etc. Now, this is one thing. But kindly have a look at the finding which is there at page 57, para 57, my lords. Which is an answer to the question, my lord. When their lordships have answered the question, my lord, they have said this, my lord. Thus, the application of the provisions of 309 CRPC at the stage of inquiry is to be understood in its correct perspective. Then, the power under 319 can be exercised only on the basis of evidence adduced before the court during a trial. They do not, when the final conclusion is arrived at, when the question is answered, the lordships have not said that it has to be exercised only till the judgment is pronounced. That is an answer, but they said the evidence has to be,
Read the next sentence.
yes, madam.
So far,
So far as the application during the course of inquiry is concerned, it remains limited as referred to herein by adding a person as accused whose name has been mentioned in column 2 of the charge sheet or any other person who might, that is with respect to an inquiry, my lord. But I am concerned with the trial, my lord. Inquiry is not an issue before this honorable. As far as trial is concerned,
are you coming up with a proposition that today judgment is pronounced, sentence is also awarded?
yes, my lord.
Tomorrow an order can be passed under section 319.
That is my first submission. Yes, my lord. That is my first submission.
But I don't think the Advocate General has gone so far. Correct?
Yes.
According to the Advocate General, it has to be done
Before sentence.
either before sentencing or simultaneously with sentencing. Sentencing cannot be done today, 319 cannot be passed tomorrow is your contention.
Please.
But according to the Solicitor General, it can be done even
Can be
tomorrow.
done. That's my
Well,
submission.
he can
That's-
refer to para 42 also, well, if he wants support from that. Para
So,
42.
then tomorrow, then after a week, after a month,
My
after
lord,
a year.
kindly have a look, my lord. Then the test of proximity, whether it is malafide, whether it is the test of proximity, etc., may be applied. But there is no prohibition. My contention is 319 does not prohibit the passing of an order after the trial, my lord, is over. The language of 319 is not such that the order cannot be passed after the trial is over. The language is clear. The language only says the evidence collected during the trial. Nowhere in section 319 is a reference, even directly or indirectly, which suggests that an order under 319 cannot be passed after the trial is over. I'll illustrate, my lord. I'll illustrate by an example what will happen, my lord.
So you want us to ignore the words
I'm
in
saying-
para 40, no, you want us to ignore the words in para 47.
No, I'm saying that for para 47, we'll have to read in along with para 57. And if
There is nothing conflicting between the two.
the para 57 is an answer to the question number 1, my lord.
57, para 57 is limited to
Limited here in
what type of evidence can be taken into consideration. The power under can be exercised only on the basis of the evidence. There is nothing contrary to each other. Para 47 deals with the stage at which it can be exercised, and para 47 deals with what type of
Yes,
evidence can be taken into consideration
To
for
that
exercising
extent, my lords are right. But my submission is that the language of section 319 doesn't envisage such a thing, my lord. It can, if section 319 is read,
I think
Right
it's better
there.
you limit to saying that even after judgment, don't say at any point of time and.
no, I'm not saying any point of time.
Stretch it to.
Even after the judgment,
Done
in
it.
a
Because that will
Proximate-
not be the reference.
proximate to the delivery of the judgment, also the power is to be exercised. I'll tell my lords why, my lord. I'll give an illustration also, my lords. And why, my lord, this otherwise,
If we accept your argument, Mr. Solicitor, what is the limitation under the CRP to take cognizance? It will go up to the limitation period.
1 year, 3 years.
We don't know.
but take a case, my lord. I'll just give an illustration, my lord. Take a case, my lord. I'll just give an illustration. So the ultimate my endeavor is to see that justice is done, my lord. Take a case where, say, a rape is committed on a minor girl by two persons, A and B, my lords. This girl gives a complaint in writing to the police. B is an influential person, my lord. He manages with the police, and the charge sheet is filed only against A. Kindly have a look, my lord. And in the trial, during the evidence, it surfaces that the letter was written, and this girl says that the rape was committed by both A and B. In a cross case like this, if no order is passed, suppose the prosecutor doesn't give an application of 319, it's not necessary. The judge also doesn't pass an order under 319, and the judgment is delivered convicting, say, A. the trial doesn't take place as far as B is concerned. B goes scot-free. If this interpretation is taken, my lord, supposing at the appellate stage, my lord, the appellate court finds that there should have been an application under 319. Because if the real culprit has been exonerated, there's also evidence, my lord, that the vaginal swab says there are 2 samples of semen. One matches with A, but the other is of an unknown person. So what would happen, my lord? Grave injustice would be caused. Kindly have a look at this, my lord. Merely on a technical view of...
There may be, sorry to interrupt you, there may be the appellate court may set aside, send back the judgment, and then 319 application to be filed. That's so simple as that.
But my lords may kindly have a look. As far as...
No, that may not be an example as well.
Yes, my lord. But therefore, my lord, the appellate court may also exercise powers under 482 and say that it's a fit case where the court should have exercised powers under 319. And they should have hauled up
that may be permissible for the High Court to do under 482. Question is whether...
Therefore, I'm saying that even it can be done.
Is it permissible to the trial court to do it after a year?
If it is permissible for the High Court, then it will definitely be permissible to trial court. If the trial court comes to the conclusion that complete justice has been done.
Is 482 available to the trial courts?
No, it's not available. My lords are right. But exercising powers under 319, I'm misunderstood.
Taking it too far.
I am saying 319 as far as the trial court is
criminal
concerned.
cases. Oh my God, Raju.
So we are equating 151 with 482.
No, I'm not saying that. I am aware that the trial court doesn't have, my lord. My lords may kindly appreciate. Now, my lords may. Now, therefore, the purpose and intent of 319 is to do complete justice, my lord. My lords are aware. But even in Hardeep Singh's case, their lordships have begun by saying that the purpose of 319 is to do complete justice. A person guilty of the offence should not be allowed to go scot-free if he is
Fortunately, that question is not referred to us. The question
no,
is
I'm saying, Manoj, that
can
question.
be done on the same day.
I'm not there, but I'm saying for the purpose of interpretation of 319, that principle will have to be, that is the purpose of 319.
Yes, of course, we have to take into consideration the purpose of interpretation.
The purpose is, Manoj, if an order is passed under, my lord, 319 after the judgment, and if it achieves the purpose of complete justice, then in my humble submission, no fault can be found with such a judgment, such an order. That is my submission, my lords may kindly appreciate. Therefore, my lords may kindly have a look at 2 or 3 paragraphs, my lord, of my submissions. Kindly have a look at my note, first paragraph of my written submission.
Yes.
The courts are meant to do complete justice. If a person's complicity in an offence surfaces during the trial, requiring such person to undergo a trial for the offence, he should not be allowed to go scot-free without having the possibility of facing the trial and a possible conviction. Otherwise, there cannot be complete justice. Victim and society require full and total justice. That full and total justice must be done. Section 319 has been enacted with a view to achieve full justice. Provisions of 319 must therefore be interpreted in a manner to further this object of achieving complete justice and not accept a view which will result in rendering partial or incomplete justice. But the moment it is held that after a judgment, after rendering of the judgment, the accused who is otherwise appears to be guilty cannot be tried for an offense, it would result in rendering incomplete justice. The courts are meant to render full justice, total justice, complete justice, my lord. Therefore, to hold that as far as the merely because an order is passed at a later stage, maybe an hour late or maybe the next day, would not permit an accused who is otherwise guilty to go scot-free, my lord.
Yes.
If that purpose is kept in mind, my lord, then the
But if we
3-1
accept your argument,
Yes.
the court will never become functus officio.
Yes.
Correct?
for the purpose of 319, my lord,
And the concept of finality of the proceedings will never be seen.
but there, my lords may kindly appreciate, my lord. The court may become functus officio if unreasonable time has elapsed.
No. The moment your sentence is, the order of sentencing is passed.
Past.
In fact, those days, when a death sentence is passed, the pen used to be broken.
Yes.
Yes, ma'am.
So now it's only ballpoint pen, therefore it automatically breaks.
It is
Or it dries up.
It is now also done. Not even the Honorable High Court also when confirms it. It is even now done.
No, we don't.
It is now even.
We had this practice long time in Chartered High Court, but then once the pen is broken, it is an indication that his authority also sees the
Functus-
stamp.
Nowadays, it is only seen in the films.
So that is a sign of it was a symbolic recognition of the principle of functus officio, probably.
Therefore, my lords may kindly have a look at those three judgments, my lord. Sashikant,
Huh? Royal court.
Breaking.
Your government property. Breaking government property is also a.
kindly have a look at those three judgments, my lord. Sashikant, Rajendra and Babubhai Bokaria.
All.
Sashikant, my lords are aware, my lord.
Yes, sir. Yes, sir.
But the application was given, the order, my lords, ultimately after the trial, but the effect of 319 came after the trial, my lord. I kindly have a look. In all the three cases, the effect is after the trial. If in appellate or other proceedings, an order under 319 comes into effect after the trial is over, my lord, surely because there is some delay as far as the order is concerned, which has been actually passed by the magistrate, should not be looked down upon, my lord. That is my submission. This is the next. Now kindly have a look, my lord. As far as the third submission is concerned, my lord. The third submission, my lords may kindly have a look. Assuming that the order could not have been passed, my lord. Assuming that the order could not have been passed after the trial is over. There, my lords, there are three judgments on which I am relying upon, my lord. That order cannot be set aside. Kindly have a look at three judgments on this point.
Brother, if you want to, brother,
That the quality of evidence is not sufficient. It can be set aside on the ground that the evidence is not of such a character that it would result in conviction, which is required for 319. That is one thing to say. But if there is evidence of sterling quality which requires that the person should be tried, and supposing the order is passed after, my lord, the trial is over, and my lords hold against me as far as the first two submissions is concerned, then also, my lord, such an order cannot be struck down unless prejudice is pleaded and proved. That, my lords, we kindly have a look at page 51 of my three judgments, my lord, on this point. 51. That was a case of illegality in investigation. But 465 applies both to investigation as well as orders of the court. Kindly have a look at last two lines of 51, my lord. It could thus be seen that this court has held that the cognizance and trial.
Where are you, Mr. Raju? Where are you reading?
Page 51 of my judgment compilation, my lord.
That is particular.
Volume 2, my lord.
Vertigo marketing.
Vertigo, my lord.
Uh-huh.
My lord.
Second compilation.
Yes, my lord.
Volume 2. Yes.
Judgment which is authored by my lord Justice Gawai, my lord. It could thus be seen
Yes.
that just above Pleasant MH, that this court has held that the cognizance in trial cannot be set aside unless the illegality in investigation can be shown to have brought about miscarriage of justice. It has been held that the illegality may have bearing on the question of prejudice or miscarriage of justice, but the invalidity of investigation has no relation to the competence of court. To also be opposite to note the following observations of this court in the state of Karnataka versus Kuppuswamy Gaundu, considering the provisions of 465 CRPC. The court, however, observed that the provisions of section 465 cannot be made use to regularize this trial. No reasons have been stated for this conclusion. 465 reads as under. I'll skip, my lord, since it has been read. But if no prejudice is caused to the accused, it is not disputed that this question was neither raised by the accused at the trial, nor any prejudice was pleaded either at the trial or at the appellate stage. Therefore, the absence of any prejudice such reading it presentum E, my lord.
Yes.
It is provided the finding or sentence passed by a court of competent jurisdiction could not be set aside merely on the ground of irregularity if no prejudice is caused to the accused. It is not disputed that this question was neither raised by the accused at the trial nor any prejudice was pleaded either at the trial or at the appellate stage. And therefore, in the absence of any prejudice, such a technical objection will not affect the order of sentence passed by the competent court. Apart from 465, Section 462 provides for remedies in cases of trial in wrong places. Section 462 reads as under. But I will skip 462 because it was with respect to trial taking place as a wrong division. Then, my lords, kindly come to paragraph 25 onwards.
Yes.
It could thus be seen that this court has held that even for the sake of argument, the CBI had committed an error or irregularity in submitting the charge sheet without approval of CVC. The cognizance taken by the learned specialist on the basis of such a charge sheet would not be set aside, nor could further proceedings in pursuance thereof be quashed. Recently, a bench of this court had occasion to consider the aforesaid provisions of the Delhi Special Police Establishment Act and so. But that I may skip because kindly come now to para 27. In the present case, there are no pleadings by the public servants with regard to prejudice caused to them on account of non-obtaining of prior consent under Section 60 of the DPSC Act, rather specifically in addition to general consent in force, nor with regard to miscarriage of justice. Therefore, this has to be pleaded and it has to be proved. Now, kindly have a look at the next judgment, my lord. Kuppuswamy Gaundu's case, 87-2, it starts at page 55. Kindly have a look at para 14, my lords. Yes. Para 14 was extracted in the earlier judgment, so I may skip para 14 at page 60. Kindly come to para 15 at page 61, Manoj. It is therefore clear that even if the trial before the third additional civil and session judge would have in a division other than Bangalore metropolitan area for third additional civil and session judge is also notified to the session judge, still the trial could not have been quashed in view of section 462. This goes a long way to show that even if a trial takes place in the wrong place, where the court has no territorial jurisdiction to try the case, still unless failure of justice is pleaded and proved, the trial cannot be quashed. In view of the matter, therefore, reading section 462 along with 465 clearly goes to show the scheme of code of criminal procedure in that where there is no inherent lack of jurisdiction, merely either on ground of lack of territorial jurisdiction or on the ground of any irregularity or procedure, an order or sentence awarded by a competent court could not be set aside unless prejudice is pleaded and proved and will mean failure of justice. But the absence of such a plea merely on such technical ground, the order or sentence passed by a competent court would not be quashed. Now, kindly have a look at 462, Bharat. This is not an irregularity which vitiates the proceedings.
No, Mr. Solicitor, actually both 462 and 465, they use three expressions: finding, sentence, or order.
Yes, Bharat.
What is done under section 319(1) does not fall under any of these three categories. Therefore, 465 and 462 can be invoked after conviction or whatever. But 319, when an irregularity is pointed out after conviction, then the question of prejudice has got to be tested because it concerns a finding, sentence, or order. Just see the difference.
Yes, Bharat. Kindly have.
Both 462 and 465,
Yes, Bharat.
they deal with finding, sentence, or order. These three words are conspicuously absent in 319. Therefore, you can't take shelter under 465 and say prejudice should be established.
But kindly have a look, my lord, at 461. I'm sorry, 461 first.
That applies only to magistrate.
Yes, my magistrate would include, my lord, because here is a court of original jurisdiction, so he would take cognizance under 190 also, my lord. Therefore,
No, he takes cognizance 193, not 190.
if it is a sessions court, my lord, the issue is
193.
if it's a sessions court, yes, but some courts have held that when a special court is neither a sessions court nor a magistrate's court. Therefore, in many cases, they say for bail applications 437 applies, but that is a different thing. my lord.
Whatever it is.
But I'll come to 465 direct, my lord. Subject to the provisions hereinafter, no finding, sentence, or orders passed by a court of competent jurisdiction. But 319 is an 319 order is an order. My lord. Kindly have a look at 319 in this case. It's an order. With great respect, my lord. Kindly have a look at 319.
Court may proceed.
That's all.
That's
But court may proceed, but that will proceed after an order has been passed. It cannot proceed in vacuum. There has to be an order under 319.
No, this 319 does not use the expression order. Therefore, when you invoke 465,
Yes,
it
my lord.
must relate to a finding, sentence, or order. And ejusdem generis, order, the word order should be read ejusdem generis.
My lords are right to that extent, my lord. The word order, but in fact and in reality, order has been passed under 319. And my lord, ordinarily, my lord, the court proceeds after it passes an order. It is unheard of that the court doesn't pass an order and takes straight away proceedings under 319.
Not an order for the purpose of 465. Only after the conviction. That's right. That's it. Ejusdem, that is why the order. Finding, sentence, or order. Order should go along with finding and sentence. It can't relate to 390.
Yeah.
It can't relate to 390.
And the concern only of the sentence is the correctness of the sentence, not kind of say after finding or sentence, when reversible.
Correct.
There has to be finding.
So that's why 465 is not applicable, is what we are trying to point out.
Yes, sir. Please proceed.
Kindly have a look, my lord. It is not
Please
only
proceed,
sentence,
please
my lord,
proceed.
sanction, etc. is also covered. Kindly have a look at 465, my lord. Subject to the provisions hereinafter contain, no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeals, confirmation or revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before the trial, before or during the trial. So it is an order in other proceedings before or during the trial. It would cover, my lord, 319 proceedings. It is not restricted to sentence and, my lord, order pertaining to sentence. Otherwise, other proceedings before or during a trial would become redundant. Or in an inquiry or other proceedings under this code. In an inquiry under the CRPC, no sentence is passed. Or any error or irregularity in any sanction for the prosecution. They have nothing to do with sentence. Unless in the opinion of court, a failure of justice in fact has been occasioned. So it is not restricted to order but anything done during the proceedings. Then, my lords, may kindly have a look at subsection 2. In determining whether an error, omission, or irregularity in any proceedings under this code, or any error or irregularity in any sanction for the prosecution has occasioned a failure of justice, the court shall have regard to the fact whether the objection could have or should have been raised at an earlier stage in the proceedings. So it covers all types of proceedings. And, my lord, 319 is a proceeding, my lord. Now, kindly have a look at Ratiram's case, my lord. It was not at the
No,
stage.
this has to be read in entirety too. Read again.
Yes.
Read this provision in its entirety. When can you apply subsection 2? You may be right. It is applies to the proceeding, but read it in its entirety.
Yes, my lord.
Read subsection 2.
In determining whether any error, omission, or irregularity in any proceeding under this code, or any error or irregularity in any sanction for the prosecution has occasioned failure. So two things it contemplates.
Read further.
The court shall have regard to the fact whether the objection could or should have been raised at an earlier stage in the proceedings.
No. Therefore, it
Court
is
shall have
read together. No?
any sanction. I'll read again, my lord. In determining whether any error, omission, or irregularity in any proceedings under this
Court shall have regard to the fact whether
the
objection
objection
could or should have been raised at an earlier stage in the proceedings.
So this also envisages that it could be at different stages,
All right.
not necessarily at the stage of judgment or sentence, my lord.
All right. We have understood. Yes, sir. Next.
Then, my lords, kindly have a look, my lord. Now, kindly have a look at the facts, my lord. It was not at the stage where it was applied. Well, paragraph 1 and 2, my lord, at page 71. Pursuing divergent and contradictory views as regards the effect and impact of not committing an accused in terms of 193 of the Code of Criminal Procedure 1973, in cases where charge sheet is filed under Section 3110 of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, and cognizance taken by the special judge under the Act, two-judge bench thought it apposite to refer the matter to a larger bench, and on the basis of said reference, the matter has been placed before us. Therefore, whether without commitment the cognizance could have been taken was the issue, and it is in this context that 465 has been applied. Para 45, my lords. And para 49, my lords.
It's supposed to be a suit for special issue.
case after conviction.
Ah.
That I must point out at para 63, page 89.
Which,
Same judgment.
Page 89.
Page 89.
all right, 89.
Yes, madam.
Hmm. Yes.
The issue regarding whether this court could have taken cognizance without committal, etc., was raised after the conviction, I must point out. But the issue was relating to a stage not pertaining to the sentence. That's what I just wanted to point out. Then, my lords, may kindly have a look at, my lord, as far as the scope, etc., is concerned of 319 is concerned. Two things, my lord. One is as far as the words proceedings which are used in 319, it will have to be read in the context of, my lord, chapter, which is the chapter? Pertaining to commencement of proceedings, my lord. Now, kindly have a look at, my lord, section chapter 14, my lord, cognizance of offences by magistrate. And, my lord, conditions requisite for initiation of proceedings. So when 319 talks of proceedings, it contemplates proceedings as envisaged by chapter 14. And chapter 16, commencement of proceedings, my lord.
They are all enquiry stage, right? Enquiry stage.
Issue of process.
See, right, up to the stage of trial, enquiry stage.
Yes, my lord.
After trial, put an end. After the trial, that's
Yes,
all.
this is one thing, my lord, which I must
That's all.
point out as
Mr.
well.
Raju, please proceed. We have understood all these things.
But second,
If
it
there
was,
is anything, any other point you come.
yes, my lord.
come out
Secondly, it
with
was
any
said,
other
my lord,
point.
it was said that the proposed accused who sought to be added has to be heard. That proposition.
No.
That I was.
Mr. Nagmazu tried to argue it before me in some other matter. No, he didn't argue it here.
Then I'll not make that statement.
He was appealing for a client.
Yes. Yes, Manu, then there are 2 or 3 more issues. Manu. But take a case where you summons under 319 before conclusion of trial.
No, we were just saying we were just saying that there you were appearing for a client.
Here he is appearing as an amicus.
Neutral body.
There you stated law correctly.
As a true friend of the court.
Here.
Yes.
Yes.
But kindly envisage the situation, my lord.
Luckily, you are not bound by whatever you said in some other case here. No, you need not stick to that argument principle.
Or not bound by whatever
I
you
thought,
decided.
my lord,
Yes, sir. Yes, sir.
but take a case, my lord, where a summons has been issued to a person under 319 to appear before the conclusion of trial. He doesn't appear and he absconds for a number of years. My lord, the trial has to be concluded as far as the other accused are concerned,
Yes.
already facing trial.
Yes.
And my lord, therefore, my lord, it would make little and after the trial is over, he surfaces. My lord.
Yes.
Therefore, proceedings will commence after the trial is over.
Yes.
Therefore, it makes little difference, my lord, whether the proceedings have been I mean, 319 order is passed before the trial or after the trial, because the result of that order can also take place after the trial is over in a given situation.
Yes. All right, sir. This we have understood. This has been argued throughout. All right. What is the other point you want to say?
It's not correct. He must be cessation of that evidence.
Then, my lord, there is Najib's case, my lord, where I have said that when joint trial can be held, my lord, those principles are given in that Najib judgment is the first judgment in my second volume, my lord. And it starts at page 1 of my second compilation. And your lordships have held, my lord.
Naseeb Singh, is it?
Yes, Naseeb Singh.
Naseeb
Singh is,
What happened? Is he convicted? This Naseeb Singh here?
but kindly have a look at.
Because his Naseeb is good or bad, we have to test. Naseeb.
Para 49, my lord.
All right.
The judgment in Chandrapal's case therefore lays down three significant principles on joint trials. A separate trial is not contrary to law even if a joint trial for the offences along with other offences is permissible. The possibility of a joint trial has to be decided at the beginning of the trial and not on
That even they are also not pressing that there has to be a common trial.
Very well. This,
All right. We will, yes.
therefore, ultimately, my lord, summing it up, my submissions are threefold. My lord, first, the reading of 319 doesn't contemplate, my lord, that the order has to pass during trial.
During the stage of the
And
trial.
my lord, the purpose and the intent of the legislation is this.
Yes, yes.
My lord, prejudice has to be pleaded. These are my
Yes.
three submissions.
Thank you.
Thank you. Prasad, 10 minutes, huh?
Yes, my lord.
Because we have no rehearing.
Yes, my lord.
Only concentrate on your.
Yes, my lord. My lord, I am appearing, my lord, in SLP Criminal 6960 on behalf of the state of Union.
All right.
My lords, today your lordships, my lords, are faced with an issue of not when, but till when the 319 can be invoked. my lord.
Correct.
That is the question, my lords, which your lordships have.
Yes.
And so therefore 319, when it says during the course of the inquiry or trial, so what do you mean by trial? Milords, trial has been codified under the CRPC, Milords, in chapter 18, 19, 20 and 21. Milords. One is sessions trial, second is Milords warrant case trial, summons case trial and a summary trial. Now Milords, may kindly see all the four chapters. All the four chapters have separately given a section for acquittal or conviction. Because the question before your lordships and what your lordships are seeing is whether once a judgment has been pronounced, then whether 319 is applicable, or when the hearing has been completed, then it is applicable. So, my lords, may kindly see the chapters first. My lords. Chapter 18, 19, 20 and 21, my lords. My lords, may kindly see it. My lords, when it comes to chapter 18, that is the sessions trial, Milords, 235, section 235 discusses about judgment of acquittal or conviction, Milords. Milords. Now, Milords, when your lordships come to warrant case, Milords, if your lordship sees, it has clause C which says conclusion of trial. What is conclusion of trial just before section 248? 248, the heading conclusion of trial means either acquittal or conviction, absence of, and so therefore, this aspect, Milords. The trial, Milords, with greatest of respect does not conclude, in my respectful submission, till the judgment is pronounced, and the judgment which is pronounced has to include the judgment of sentencing if it is a conviction, Milords. I'll make good that proposition, Milords. Now, Milords, may kindly see thereafter chapter 20, which is a summons case. Summons case also has section 255 for acquittal or conviction, Milords. and also the summary trial has the same aspect. My lords, if the conviction or acquittal should or could not or should not have been intended to be part of the trial, it should have come in a general provision or separately, not exclusively with all the such chapters of trial, my lords. My lords, first point, my lords. So, my lords, my argument is, my lords, and my submission is that the acquittal or conviction aspect is a part of trial. Then comes, my lords, what is a judgment of acquittal or conviction? I'm not on acquittal. As far as conviction is concerned, my lords, the judgment is section 350, section 353 CRPC. It has to be read with, my lords, 354 1C also. What should be the content of the judgment? If a judgment is passed only of conviction and no sentence is there, it is not a judgment, my lords, a valid judgment. My lords, may kindly see section
This
354.
was argued by learned advocate general, and we have said for the present we agree with him. For the
My lords,
present.
my lords, yes, my lords.
All right.
Now,
Now,
let's-
proceed, Prasad. This is,
Yes,
don't
sir.
repeat all these things.
No, my
You have
lords.
understood.
Two judgments of your lordships.
What judgments you want?
Yes, my lords. One was, my lords, 2013-13. My lords, only 3 paragraphs which
All right.
discusses about judgment,
Give that book.
and my lords, 1995 to SCC.
Huh?
Ram Naran, yes. It was, so this aspect,
Not Ram Narayan. But
Ram Naran.
Ramanaran.
Because your lordships were discussing Ram Naran, but it's Ram Narang versus Ramesh Naran.
Narayan. So why do you bring Narayan along with Ram? We have Ram with us.
No, he's Ram Narang, my lords.
Narayan.
Only, my lords,
I think it's Ramanaran.
Rama Naran. Yes, yes, my lords.
Ram.
Ramanaran versus Ramesh Naran.
Ramesh Naran. Yes, my lords. My lords, only paragraph 15. Five to SCC, page 513 at 524 under the provisions of the code law. I'll just read it for your lordship's convenience.
Right?
Milords, starts at 513, paragraph 15, my lords, at 524.
Yes, we have.
My lords, under the
paragraph
provisions
15.
of the code to which we have already referred, there are 2 stages in a criminal trial before a session court. The stage up to the recording of a conviction and a stage post-conviction up to the imposition of sentence. A judgment becomes complete after both these stages are covered. So, my lord, this is for the purposes as to what is a judgment. So, 353
So
read.
you also agree that once a sentence is imposed,
Yes, my lords.
conviction is recorded, sentence is imposed, then the judgment is final.
Yes, my lords.
So thereafter,
Thereafter, 482 power may be invoked in case there is a problem.
then thereafter the court cannot exercise powers under
Yes,
319.
but till the sentencing, it can be simultaneously.
You are arguing on the same line as
Yes.
the learned
And my lords,
advocate.
why
You
your
don't
lord?
want to go to that extent as the learned solicitor.
No, my lords.
wants.
No, my lords. I'll restrict myself up to this. My lords. No, my lords, your lordships have said,
It's a Hardeep para 47 is final.
my lords. My lords, problem is there are
Hardeep, you know, the only problem we found in Hardeep, they have not defined what exactly a judgment means. It is only 353 read with 354 becomes judgment.
yes, my lords. My lords, my lords, Hardeep was, your lordships were faced with the question when to start. The scope
The
of,
question was whether during the course of inquiry,
yes, my lords.
and what is course of inquiry?
Yes, my lords. So therein your lordships had expanded the scope of 319. Today your lordships are faced with a situation where to close it,
Daily.
where it will end. There your lordship started saying any time after a particular aspect. Today your lordships have to see when to end. Now, my lords, in my respectful submission, it ends only and only the judgment is pronounced, which includes the judgment of sentence. My lords.
Yes.
My lords, 319 your lords.
Supposing in a given case,
Yes, ma'am.
judgment under 353 is pronounced.
Yes, my lords.
Thereafter, the 319 application is allowed.
Yes, ma'am.
Thereafter, sentencing. it is permissible.
Yes, Manoj. I'll say
what
so
you
why.
want to
Manoj.
suggest.
Because even when the sentencing is done, Manoj, the court looks into the mitigating circumstances on the basis of which a sentence is to be passed.
Mitigating as well as aggravating.
Yes, Manoj. Both ways, Manoj. So, Manoj, and your lordships have said in Hardeep Singh that when the court is exercising the power of 319, it is an extraordinary power. You cannot simply say yes, as your lordships had asked, what if the complainant names anyone? No, because it may. But when you are calling someone under 319, the purpose is, and the magistrate has to keep in mind, the court has to keep in mind that whether that person with the evidences available can be convicted and the chances of his conviction is
You have
low.
understood,
So
Prasad.
therefore,
Go to the next point. Go to the next point.
yes, Manoj. Manoj, thereafter, Manoj, these the evidence and Manoj, it has to. Manoj, I think the judgment.
2013,
Page number
2013.
2000.
Manoj, 2013, volume 13, SEC, page 1 at para 106. It's a reference in Yaqub Menon's case that it is clear that a conviction order is not a judgment as contemplated in a 353 and that a judgment is pronounced only after the award of sentence. Manoj. This paragraph read with 113 and 114.
All right, all
So
right.
therefore, Manoj, this is my short submission.
All right, all right.
Lordship, please.
All right. Yes, sir. Mr.
But
Patwa.
only one submission.
Yes.
Milord, why did I say, Milord, after the judgment is delivered? Because the court becomes functus officio, Milord. There is a judgment by this honorable court in the Vinderpal Buller's case. After the decision, it becomes functus officio. So, Milord, I said 319, it can't deal thereafter. So that is why I said I can pass on the judgment. I'll
Fairness on your part.
Very nice.
The court cannot, Milord, thereafter.
Which is that citation?
Well, 2012, I'll give you AIR 2012, Milord, Supreme Court. 364, Milord, I'll give the judgment.
All right.
Your Lordship, I
The
appear
file
that-
was taken up by the Honorable High Court, Milord. The case was decided, but after 15 days, again the file was taken up and the order passed. The court has dealt with the entire issue.
All right, sir. Yes, you wanted to say something?
Please, Your Lordship.
You are for whom?
Because I appear in IE number 172-980, Your Lordship had indicated I can argue for 5
What
minutes.
is that you want? I will.
Only for on the points of assistance, Your Lordship, with regard to the concept of whether the just mere fact that the judgment has been pronounced.
Who
plus-
are you?
Because I file an implement.
Why do you want to assist us with so much of assistance?
Because I was
No, but
only
you have filed an implement, but on whose behalf?
because on behalf of the Delhi Prosecutors Association, Your Lordship, I have Delhi Prosecutors Association. Your Lordship, I
What is
indicated.
your role in this case? What is
Because
your
Lordship only as assistance, not on the facts of the case.
Tell us. All right.
Points because everything has been summarized.
All right. Tell us.
Your Lordship, mere fact that the pronouncement of judgment has been done. Conviction.
What does this matter to do with the welfare of the Delhi prosecutors?
But it was only to assist Your Lordship, only to make some legal submission, only 2 submissions. Most of the submissions have been incorporated.
What if they can file applications after judgment?
No, Your Lordship.
See, you are also bound by 319, no?
Yes, Your Lordship, this is what I am submitting.
No,
That
here you can. How can you file an application in 319?
In fact, if you have done your job properly, this reference would not have come.
Please, Your Lordship. That's why I mean,
Prosecutors.
there is a difficulty with regard to that part. But that's only 2 submissions, if I may.
All
Your
right.
Lordship's
Please,
permission.
please.
Whereas the only consideration which this honorable court has to make whether mere pronouncement of judgment makes a judge functus officio. It has already been argued that till the time sentence is imposed in a judgment of conviction, the judge has the jurisdiction. Section 235 says.
Don't repeat. This is argued. Something new. This is argued extensively.
There's one more, only section 236, 2 provisions which will show that even after pronouncement of judgment, the judge is required to act under the statute. 236 says that in case there is a previous conviction charged, there are offenses when there is a subsequent conviction. In that case, the judge, even after the pronouncement of judgment, is required to take evidence. Even after the pronouncement of judgment of conviction, is required to take evidence. Your Lordship may kindly have
Evidence for what?
for alleged previous conviction. Lordship may kindly have section 236. This would show that
For the purpose of sentencing.
yes, Your Lordship.
That is well taken.
No,
Well
not
taken.
sentencing under 235, under the enhanced sentencing because there is an accused who was previously convicted for some other offense. If a previous conviction of that offense is going to be
Which
aggravated,
provision? Which
236, Your Lordship.
236.
Yes. Yes. Taking the part. What should I kindly have 236?
That should be one of the considerations.
Yes.
For conviction. Well
Yes.
taken, sir, well taken.
Sentencing in the present
It
case.
is sent-
Everything will be heard, all these questions will be heard after conviction is, judgment is in which provision?
235.
But for sentencing in the present case about the other cases. So sentencing includes that one.
Ms. May I
That
just,
is concurrent.
Ms.
or
236
That should be
says,
concurrent or separate.
yes, I am relying on that the word is to take evidence. So that if a judge is declared functor, if you say that trial concludes when only a judgment of
Don't repeat the arguments. The Honorable Advocate General, as well as Mr. Prasad, have already said that the judgment doesn't complete with the order of conviction.
order,
It continues till
Your Lordship.
the sentence is finally imposed.
It's only for the purpose of.
and similarly in section 248, the same is repeated.
All
And Lordship, one last submission is with regard to, Milords, there is an issue, Milords, what is the right stage when the application under section 3119 should be made by the prosecution? Because all this entire issue has arisen because there was a delay in making the application. There was a delay in disposing the application.
There was no delay in making the application. The delay was in deciding the
Lordship,
application.
under section 276, even under delay was also there when the witnesses were examined. Because under section 276 of the CRPC, the judge has to take the evidence under his dictation and it is signed and the prosecutor is present. So if that would be the right stage for a judge to take cognizance under section 319 or for the prosecution to file an application under 319. They should not wait till the final conclusion that, okay, now every witnesses have been examined.
On question number 3. Guidance.
Look, these are my
We have sufficient guidance from you now.
well, we are
All right,
here to
all right,
learn.
sir. All right. Yes, sir, Mr. Patel.
May it please. Pronounced anything,
We'll come at 2, sir. We'll come at.
All. Go just. Whatever your lordship thinks.
Take 15.
All. Now, Lord, let me just first point out. The issue which I propose to address here now is whether once conviction or acquittal is pronounced, 319 power can be exercised thereafter or not. Let me, before I start, say, in my case, it is very obvious from the facts of the case that actually both had happened before 319 was passed. That's a matter of fact because the file had been consigned to the records after conviction was recorded. That is recorded in the order of, after sentence was awarded. That is recorded in the order of sentence. And in 319, the last line is, Elmad is directed to re-requisition the file.
Well, yeah, we are not deciding the.
So therefore, I start with that.
Please focus only on this. Ultimately, see, Advocate General was very fair, to be honest. And the only point perhaps was, what is that last stage?
Yes. So,
Whether the award of sentence
I'm
also
straight away.
cover
That's all I'm going to
for judgment or not.
But I'm only saying I'm doing it as an officer of the court to assist your lordships to come to a correct conclusion in law and not because I am bound by my facts of the case will survive either way. But now with this background, 2 lines in Hardeep Singh and a glance over 3 sections and then my submission.
All right, all.
Kindly have Hardeep Singh, page 121, para 40.
1 second. Para?
40.
40.
Even the word course occurring in section 319 clearly indicates that the power can be exercised only during the period when inquiry has commenced and is going on. Please mark these words. Or trial which has commenced and is going on. It covers the entire wide range of the process of pre-trial and trial stage. The word course therefore allows the court to invoke this power to proceed against any person from the initial stage of inquiry up to the stage of conclusion of trial. So, and is going on means something live and going on. Now have para 47, 1 line, and then 3 sections to make the submission. Para 47. Since after the filing of the para 47,
Yes, we have.
since after the filing of the charge sheet, the court reaches the stage of inquiry, and as soon as the court frames the charges, the trial commences, and therefore the power under 319 can be exercised at any time after charge sheet is filed and before pronouncement of judgment. Emphasis is on the word before pronouncement of judgment. Now come to the CRPC. 3 sections. What is the point? Point is, when we'll read 353, 354, we will see judgment is in 2 parts. Question before your lordship is not when judgment is complete. That's not the question. The question before your lordship is the stage at which 319 can be applied.
Yes.
And my submission is the moment you enter the arena of judgment by recording, actually, not in loose parlance, when we talk of, we say a judgment and of conviction or a judgment of acquittal. That's how the judgment is titled. And then order on sentencing. But there is that is loose parlance, it is utilized. But my submission is the moment you enter into the arena of 353, 354, and the moment you announce the judgment, because both the judgment you will announce in 2 parts in case there is conviction, the judgment will be complete on the first part if there is acquittal. In the facts of this case, just in a fact of a case, you can have 6 accused, 3 acquitted, 3 convicted. So far as the acquitted accused are concerned, judgment is complete. Trial is over. So you can't have 2 yardsticks. Your lordships, when your lordship will lay down law, and in a combination of this, it has to be definite and sure. And that is the letter of law also. Now just kindly have 353, 354 with me. That's the only way of interpreting. We are wrongly going into functus officio. We are wrongly going into when judgment is complete or incomplete. We need not go into that. your lordship will have to see when power can be exercised under 319. Now, after you have convicted it, the court actually loses a lot of power of a live trial. Therefore, if your lordship remembers yesterday, when your lordship posed to me that is it your argument that after you reserve it for judgment, you have lost power? I said, no, you have not. But then you have to make an order and you are not entered into the arena of 353. You will have to await the judgment till your exercise of power under 319 is complete. Mr. Nagamuthu said, and he reconciled the judgment of Chief Justice in that separate trial with 319 very well by saying, and that's according to me, I also agree with my learned senior counsel's submission. According to me, when 319 order is made, the accused comes, then the judge has the occasion to make up his mind whether he wants a joint trial, whether he wants a separate trial, whether he wants to conclude the first one. That can only happen if the judge has not entered into the arena of 353. The moment he enters the arena of 353, 354, by announcing acquittal or conviction, he is already in judgment. He has pronounced judgment. We cannot say judgment is not pronounced. Judgment is pronounced. All that remains is the sentencing part of the judgment. And for those whom he has acquitted, nothing remains.
So are you saying sentencing is not a part of the judgment?
I am saying sentencing is a part of the judgment. The judgment is in two parts. Now, let me not say it myself. Let me read 353, 354, and then say whatever else I have to say.
Court
Yes.
judgment. Same court. It is
Now, also other interesting thing. Nine, we are in the part of general provisions as to inquiries and trials. The moment we come to 353, we come to a different part of the code. The chapter is the judgment. We have entered into the stage of the judgment. It cannot be, then Hardeep says, before judgment is pronounced. So therefore, the moment Hardeep says before judgment is pronounced, and judgment is in two parts in case of conviction only, even if the first part of the judgment is pronounced, power under 319 cannot be exercised, is my respectful submission. Please see now 353. What 353 says. The judgment, there are 353 uses the word after termination of trial. Now, in a different context, when your lordship is considering sentencing, when copy of judgment is to be given, or when in that company law matter, which is completely alien to what your lordship is now deciding, of 1995, that Ramanaran was a case where in an interim order was passed and then some observations are made. Those are different situations. The trial, technically in Yaqub, your lordship has said trial may continue till you have finally sentenced them. But the question is, when your lordship is now going to apply mind and give a conclusion as to when 319, which says trial, and the law commission says tried with the accused. That's the law commission introducing this section. Now kindly see 353.
Yes, we have.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of trial or at some subsequent time. So the section is very clear. Judgment is to be pronounced immediately on termination of trial means the live trial is over. Nothing remains live before him now. And therefore, or at any subsequent time. Now, what is judgment? Kindly have 354.
Yes.
Except, 354 says, except as otherwise expressly provided by this court, every judgment referred to in this section shall be written in the language of the court, shall contain the point or points for determination, the decision and reasons, shall specify the offense of which and section of IPC or other law under which the accused is convicted and the punishment to which he is sentenced. So the judgment is defined to be in two parts. First part of the judgment is whether he is convicted or acquitted. And the second part of the judgment is to which he is sentenced. My respectful submission is the moment you come to this part and you have already
Yes.
if it be a judgment of acquittal, shall state the offence for which the accused is acquitted and direct that he be set at liberty. So, my lord,
Yes.
so, my lord, my respectful submission to your lordships is that when your lordships is seeing the application of 319, the 319 can be applied only up to the stage when you have not reached the stage of 353, 354. The
So according to you, suppose by in a given case, if the court starts dictating the judgment in the open court, then he can exercise power under 319 only prior to starting dictation of the judgment, and not once you start dictating.
My lord, there are varied occasions. If he starts, correct. So my learned friend is pointing out that the whole of the judgment has to be delivered. I was going to say it in a different way, but 353 says. So my submission, he starts dictating in open court. In the midst of it, he finds that no, actually this man is also there. Then before he records a finding of conviction or acquittal, then he would exercise power under 319 and according to me, defer the pronouncement of acquittal or conviction.
Mr. Patwalia, a judgment should essentially contain the contents of the judgment. Otherwise, it can't be a judgment. Now, read 354.
Correct.
Except as otherwise expressly provided, every judgment referred 353. Now, see, specify the offense of which and the section of IPC or other law the accused is convicted and the punishment to which he is sentenced.
Correct. It is in two parts.
We are dealing with a situation of 353.
353.
We are not on that question.
Is applicable even to magistrate. Therefore, law which you are not going to declare will be binding on a magistrate also in a warrant trial or in a summons case. In all cases.
True.
353 and 354 are not applicable to.
No, Nagamuthu, for example, supposing we say that judgment is complete after, in the case of conviction, the judgment is complete when sentence is awarded. Or does it have any effect? It's not a case of acquittal. Does it have any effect for trials other than session trials?
Similar provision is found, but these details need not be there. You have to see that is going on. When the trial concludes, so far as the magistrate is concerned, conclusion of trial is specifically defined. Therefore, so far as session court is concerned, there is no prohibition indicating when does the trial conclude. Therefore, not be referred to 354.
Yes.
So far as the magistrate is concerned, you have to kindly have a look for it.
Which is that provision? Magistrate power?
You have to kindly come to section 238 onwards.
Yeah, no problem. It's 248 actually, but
238 onwards. You have to.
you want to
Which is the relevant provision here? Relevant.
248.
38 onwards, we have to just have a cursory look. We'll see only subtitle.
But we'll have 2 minutes, huh? Let him.
Yeah. Yes, of course.
Tell us.
238 मध्ये this mirror part A cases instituted on a police report.
Yes.
238 onwards.
Yes.
Mirror, here you will have to kindly consider complaints of 207 accused shall be
All right, come to 248 directly. Come to 248 directly.
Yes.
Conclusion of that.
This is common. Mirror conclusion. This is common to both
Ah.
private complaint case as well as police report case.
Yes.
This is common.
Yes.
So 248 says
Yes.
exclusion of trial.
Ah.
If in any case under this chapter in which a charge has been framed, the magistrate finds the accused not guilty, he shall record an order of acquittal,
All right.
not judgment.
All right.
Yesterday I referred to section 232.
Yes.
For a session judge is concerned, he is record only an order, not a judgment.
All right. Next.
So, Murad, this is an order.
Mm.
Section 353 and 354 speak of a judgment.
Mm.
So, therefore, the magistrate need not write a judgment at all. He can write only an order. What are the contents of the order? That is there, in paragraph subsection 2, where in any case under this chapter the magistrate finds the accused guilty, but does not proceed in accordance with provision of section 325 or 360. He shall, after hearing the accused on the question of sentence, pass sentence upon him according to law. If only sentence is imposed on him, then trial concludes. Conclusion of trial.
This is in parameter 233. What is that? For
So therefore,
353 and 3.
therefore, when we are interpreting 353 and 354, we can take a clue from here.
And this should also be kept in mind.
Yes.
All right, all right.
Under, under section 353,
Yes.
the stage of judgment cannot commence unless there is a termination of trial. See, it is only after a termination of trial that the judgment can begin.
Yes.
Therefore, we have to first identify the stage of termination of trial, because that has to be juxtaposed with the words course of trial as found under section 319.
In other words,
What are the stages? Course of trial and termination of trial. Unless there is a termination of trial, a judgment cannot begin.
the trial concludes by imposition of sentence in a case of conviction.
I think so.
Concludes.
Yes.
That is the clue here.
All right. Yes, sir. Mr. Patwalia.
Kindly have 319 with me. Now, just let us analyze the different situations. In case we are going with judgment being with sentencing, let us read 319. Where in the course of any inquiry into or trial of an offense, it appears from the evidence that any person not being an accused has committed any offense. Next words are important. For which such person could be tried together with the accused. Now, the moment you have sentenced an accused, the moment you have convicted an accused or acquitted him, these words are finished. They are gone. He could not be tried with the accused. And now, just see what the Law Commission says here. Law Commission's report was fortunately given to your Lordship twice over. One by me and once by Mr. Raju Malod. Just kindly see what the Law Commission says here. Just taking my. The Law Commission's whole purpose is live trial. A live trial in the sense that it is before you are either convicted or acquitted. And a joint proceeding. Where is the question of a joint proceeding then, if this is happening? Yes, just.
The court must be citizen of the trial.
Correct, correct,
And the evidence must be live evidence.
correct. Because there. Just give me that. This is page 54. Third line from the top. It is only proper that the magistrate should have the power to call and join him in the proceedings. Very, very important words.
You are reading?
The Law Commission report, page 55, the third line from the top.
We have Mr.
32.
Raju, 130. It's fine. It is with those
Mr. Patwalia, these are all aids for construction.
No, so therefore, my lord,
These are all aids for construction.
So therefore, my lord, since your lordship is going to lay down the law for all courts to follow, let us have all possible assistance from whatever aids are possible before your lordships today.
Yes.
And it is not said once, it is said 3 times over. So I have read the third line. It is only proper that the magistrate should have the power to call and join him in the proceedings. Now kindly come a little lower, 25.81, 5 lines from the bottom. We therefore propose, your lordship has got that?
Yes.
5. My lord, may also. The whole purpose is to make him join a trial which is still live, when he can still join with the accused there. That's the whole purpose of 319. We, now just kindly have the last 5 lines. We therefore propose to recast section 351, making it comprehensive and providing that there will be no difference in the mode of taking cognizance if a new person is added as an accused during the proceedings.
But well, yeah,
And-
we will accept what you said for the moment. Judgment is pronounced.
Correct.
Now, according to you, it can't be done after the pronouncement of the judgment and before conviction. Now, judgment is pronounced. Thereafter, it can't be done. This is what you are suggesting.
Before sentence.
Yes, I'll respond to it. One more line. Well, one more line here and I'll leave it. Just one, I'm sorry. I should have responded first, but just one line and I will and respond to your lordship.
Yes.
24.82. One more line. The offense for which the newly added accused can be tried is not indicated in precise terms in the section. Obviously, that offense should be connected with the one for which the original accused is under trial in presenti. It's in present tense. He is under trial. So therefore, it is one thing for somebody to say that in such and such judgment it is held that trial concludes with sentence. Of course, in a larger, looser way of talking, that may be true. But we are not looking at it largely and loosely. We are now interpreting a particular section of the Criminal Procedure Code, which has been added for a purpose and which tells us at what stage of the proceedings such addition can be made. Now, answering your lordship's question. Now, my lord, if we only go by sentencing to be judgment, then what is the first part of the judgment which says acquitted or convicted? And the proof of the pudding is in its eating. Kindly have this very case, the third volume, where the judgment is there. Let us see what it says.
Which judgment?
This very case,
This case.
the session court order. Let us see that. Just at the top, this is page 3. Page 3.
Third volume.
Volume 3, yes. R3. Page 3. Just kindly see at the top. Judgment. The main judgment, when we file an appeal against this judgment, what do we impugn? The judgment of acquittal or conviction. And then when your lordship says, we are not going to interfere in the main judgment, but we might interfere on the quantum under the sentence. Because that is, so therefore, when we go up in appeal, what do we impugn? It is the main judgment. And when your lordship is not inclined on the main judgment, then as lawyers, sometimes we say, or your lordship says, all right, we will go into the quantum and see if it can be undergone or lesser or whatever. So therefore, my lord, and that is how this also breaks it up at page 109. At 110. It is part of the same judgment. It's at 110. It's quantum of sentence. It's part of the same judgment. So we cannot wish away the first 109 pages by saying, no, that is nothing. Trial is still live. Let us examine it, my lord. Mr. Nagamuthu's submission was that the judge can then take a call after 319, whether he wants a joint trial, whether he wants a separate trial, whether that earlier evidence is also to be put to this accused, etc., whether this evidence can be utilized by the earlier accused. That cannot happen after you are pronounced on conviction or acquittal. The original accused says, I want a 311 because this evidence may come to my aid. If the magistrate decides to bifurcate the trial, the original accused can go up in that against that order saying that, no, sir, I don't want bifurcation. Let that evidence come. It may come in my favor. I may want to utilize it. So therefore, that can only happen if he has not announced on the conviction or acquittal. So answering your lordship's question, my submission is 353 tells us the stage read with 319. 319 read with 353 says that it is after termination of trial that the judgment is to be pronounced. 354 says this judgment has to have two components. And the moment the first component of the judgment comes into existence, the judgment is there. It may be an incomplete judgment, but it is a judgment all the same. It cannot be that after pronouncing the first part, he can change his mind. He cannot change his mind. Once he has acquitted or convicted, he can't say, oh, I was sorry, now I have seen something new. and I will now want to change this from acquittal to conviction or vice versa. The learned judge cannot do it. All that the trial remains live for him is on the quantum of sentence which he is to award, and that does not only have to be on the basis of what is led during trial. There is separate evidence, and that evidence is no evidence for the accused who is joined. So, my lord, according to me, when your lordship, and the second part of it, then your lordship is making it conditional upon acquittal or conviction as to when judgment will be pronounced. And in my case, my lord, one person is acquitted, 9 are convicted. So what happens? We have one complete and 1/10 of the judgment is complete and 9/10 is incomplete. Cannot be like that, my lord. It is one whole. That one whole is in 2 parts. The moment the first part is announced, then the power under 319 goes. It can only be exercised because it says could be joined. In 319 says could be joined.
Yes.
Yes.
So trial.
Yes. Where in the course of any inquiry or trial, the course of trial is over. That because 353 says judgment shall be announced after termination of trial. So the only way of reconciling it is that 319 can only be utilized before you reach the stage of 353. And even if you have put a mark in 353, you want to have a change of heart, then you will have to refix it. And my lord, sometimes when your lordships also are dictating judgment and a new thought comes, then the dictation is paused. Counsel are called. If it is in chambers, then your lordship puts it for rehearing. And it comes up in court. If it is in court, then counsels are called. Somebody may say, well, sir, this is a new idea. Please give me some time. I will come back. Then it is posted again for hearing. So I am not wanting to foreclose a learned judge's right to change his mind, to get wisdom can dawn at any stage. But the question is that if it dawns after he has convicted or acquitted, then it is too late for him. Then it will do violence to 319 if that is permitted to be done. And this is not, I am not now driven by the facts of my case or to protect my client. I very candidly said that even if the other part is correct, my client stands protected, according to me, subject to, of course, what the other side has to say. There are always 2 sides to everything. But the point is, my lord,
food for thought again.
Just kindly have,
After the lunch.
just kindly have the problem with reading a judgment in one line. Just have this Yakub's case, 2013.
It's more than settled that the judgment can't be read. You can't just pick up a sentence from here and there and
Correct. Now, if I
You
read
have
just
to-
one sentence,
you have to cull down what is the ratio decision.
correct. If I read one sentence of Yakub in para 88, which of course the other side didn't read, judgment indicates the termination of a case by an order of conviction or acquittal. Then Yakub is completely supporting me.
Well, yeah, what you are suggesting is, it may be pronouncement of judgment may be in part.
Correct.
But once the first part is pronounced, there is no question of trying together.
Correct.
Therefore, it will be violating 319 itself.
Correct.
This is what you are
Correct.
suggesting.
Correct. Correct.
Point is taken.
Correct.
All right, now proceed.
Now, my lord,
Now you proceed.
that is about all, my lord, that I wish to say
All right.
in rejoinder, my lord. Because otherwise they are agreeing that Hardeep doesn't have to go to a larger bench. And this same day business, once your lordship clarifies this, then the same day is a matter of fact. Because let me tell your lordship on the same day business also. If actually a 319 is allowed by a judge, immediately before he actually writes a judgment, he will not write the judgment on that day. 9 out of 10 times. He will then defer it because he is calling a new accused. It will be an extremely unthinkable position that on the one hand he is adding an accused and on the other hand he goes on to pronounce on acquittal or otherwise of the rest of the accused before. It will never happen.
To that,
It can-
Nagpatwala appears to be correct because then thereafter he has to apply mine
Correct.
as to whether all the accused who is called
Correct.
to be jointly tried with the other accused or not.
Correct.
Or as to whether the newly added accused has to be tried separately.
Correct. So therefore, if he sits down to dictate judgment, and then the learned magistrate realizes, or the learned session judge realizes that no, I am adding a party under 319, he will then defer it. He will then allow the person to be produced before him.
Yes. And once it is pronounced, first part is pronounced, there is nothing to be tried together.
Correct.
This
correct,
is what you are suggesting.
Correct.
All right. Yes, Patwalia.
And I'm grateful.
Nagapathy, you want to add?
Only one line.
Yes.
Yeah, I agree with him. Now, the moment for the first part is pronounced, he is no more like it, he becomes a convict.
He becomes a convict. He becomes a convict.
After that, Murad, he cannot be tried. It is over. So that is a point, Murad. That point of time, Murad, whatever I said.
And the word used in 319 is accused.
Yes. Accused must be there to be tried jointly or separately.
With the other.
But here he becomes a convict.
Convict.
First part is delivered, he becomes a convict.
Convict.
And therefore, he cannot be tried.
Thereafter, only quantum issue. Even if it is one day, it's a convict only.
Yes.
But only one thing on 465, if your lordship wants, I can assist your lordship.
No, it's all right. Leave it.
All right.
We have understood. All right. Anything else? Thank you so much. Thank you very much. Reserved.
Only one thing, if Milad,
Yes.
sorry, Milad.
Yes.
As far as Milad, the argument that it can't be jointly tried, Milad, I said 319, one is only for identifying the accused, and Shashikant is clear on that, that it is directory only. I can read Milad.
We have understood that.
We have
So,
understood.
Milad, if it is directory only, so there's no question of being not tried together jointly. So, jointly trying is not a condition precedent for 319. It is 319-4.
That Mr. Nagpatwala is fairly
Yes,
to that proposal.
Milad, the argument raised here is that once the conviction is there, so because he can't be tried
Attorney General,
jointly.
there is nothing like sub rejoinder.
No, Milad, only one submission.
Once my learned senior brother said that the matter is closed for our orders.
Yes.
It's closed.
Milad, I just, if Milad kindly permit me, I know Milad, my
Now we have become functus officials.
Milad, for punctus officio, Milad, only one submission. Milad, I read the order of conviction. Thereafter, I read the order of sentence. Now, file be consigned is after the sentence. So, functus officio.
What has happened is, see, all of you differ only on one thing. When the curtain is drawn on
Yes,
August
yes.
17, according to Mr. Patwalia, the moment the judgment of conviction is delivered, curtain is drawn.
Please.
According to you, the moment conviction is rendered and sentencing is passed, curtain is drawn.
Please.
According to S.V. Raju, curtain is never drawn.
Milad, it is never unheard of that appeal can be filed only on the conviction without there being sentence. Mr. Patwalia said we file appeal.
But now the
It
curtain
cannot
is
be.
drawn on this case.
So, Mr. Advocate General, in a civil case,
Please.
you can file an appeal against a preliminary decree also.
Yes, but my lord, in a case of criminal case, it can't be only on conviction. Sentence order has to be there, only then the appeal can be filed. I for the first time heard that appeal can be filed and conviction can be set aside, then we come to sentence. We never come to that.
That is not his argument.
My lord, yes, it was argued that we file a
He argued that in a given case, the court may say that we will not interfere with the conviction, but we will only interfere with the sentence.
But then the judgment, the
Mr.
sentence
Advocate
both
General,
have
now,
to.
as my learned brother says, the curtain is drawn now.
And whatever it is only with reference to 319.
Going to.
Well, yes.
Magistrates also, right, over magistrate. Yeah, the law in respect of.
Everyone, all tracks.
Yes, sir. Nagamuthu, now we'll start with your corruption case.
No, not his corruption case.
Your means your client's corruption. Thank you so much, Patwali.
And I'm so grateful. So great.
Towards your lordships and by my learned friend's presence, Lord, I have learned so much. In fact, I was telling him during lunchtime that it has been a learning experience for me.
It has been a great learning experience. So grateful.
Thank
It was a player arguing.
Thank you.
So great.
File de dana.
For whom? Welfare.
Yes.
Submitting a small note.
All right, where is it? Give the note. Here, brother, here you should. Brother, one position.
Pensions not which have been now amended in 2018. So this issue relates to the original provisions, not section 13(2), to section 13(1)(d) and section 7 of the PG Act. As it put.
Prevention of corruption. Prevention of corruption.
Now, my lord, the issue under reference is this. It is a new book, my lord. New book.
This is a new book. I think you have to go to the
2021.
unamended. You have to go to the unamended. This is a 2018 amendment. We don't need this.
We don't need.
You bring that to
No,
before
you
amendment.
kindly come to page 8, my lord.
88.
In my book.
So this is old corruption. Old corruption.
Page 8.
Old act. Coming from the language. You have the new act here.
Page 8, you will also find that 7, the old provision is found at the footnote. See there, no?
There are old provisions.
Yes, that is enough.
Solicitor is also.
taking the losses through section 7 and 13 only. Let me read the issue which has been referred to this honorable court to answer. The issue I expected page 1 of the written notes. In para 1, the question whether in the absence of evidence of complainant, mark it, so it means complainant is either dead or he has thrown half or he is not available. Direct or primary evidence. Direct, I am able to understand it is oral evidence. Primary minutes, it is documentary evidence. There can't be any primary oral evidence.
Panchanama.
Primary documentary evidence. Primary evidence.
Trap Panchanama.
Yes, demand, suppose by means of email or letter, demand is made. So that kind of document itself is sufficient to convict, to prove demand. So, second, primary evidence or demand of illegal gratification. Is it not permissible to draw inferential deduction of culpability or guilt of a public servant under section 7 and section 13(1)(d), to section 13(2) of the Prevention of Corruption Act, based on other evidence adduced by the prosecution? This is a question. But what is absent is the evidence of the complainant, namely bribe giver. If there are other evidences, from out of that a person can be convicted both under section 7 as well as under section 13(1)(d) is the question. Now, normally the complainant is examined to prove two facts. One regarding demand he will speak about, and also he will speak about the acceptance of the bribe when it is offered. That is receipt. I do not want to use the word acceptance because it has got a different connotation. Receipt. So when it is demanded, in response to that it is given, it is received. So both in respect of demand as well as in respect of receipt, the defect of complaint, namely bribe giver, will give oral evidence. That evidence is now missing as per the reference. Now, in the absence of this evidence, how are we going to prove the demand as well as the receipt for the purpose of section 13(1)(d) as well as for the purpose of section 7? Section 7 and 13(1)(d) have marked differences in the matter of ingredients. Therefore, I have extracted in my written submission section 7 first. Kindly have a look at section 7, the old one. In the book also it is there. I have also extracted.
But after the amendment, it has completely changed, is it now? The position has changed.
Slightly changed. So what are all contained in section 7?
So whatever we decide, it is applicable prior to 2018 only.
18 only, it will be applicable to after amendment also, because 13(1)(d), the provision contained in 13(1)(d) have been simply imported to the section 7 now. Slight changes. Principle to be applicable. Well, principle is how are we going to prove a fact under in issue? That's a basic issue.
In the absence of evidence of complainant.
In the absence of evidence of the complaint. If there are other evidences, whether a disputed fact, that is a fact in issue, can be proved or not, it is a simple question. I don't think.
Normally, this happens in the case of death of a complainant, right?
Death of a complainant, or he turns hostile, or he is not available. He is not available.
No, hostile means his evidence is available.
He says, I did not demand, she did not demand, I did not give.
That's a matter of appreciation.
Complete hostage.
It's a matter of appreciation.
That is on appreciation.
That is why this
Appreciation.
the whole issue, with great respect. But I decided by the judge before the case is pending, case to case, it is to be decided on facts. It falls squarely within the domain of appreciation. There is no legal issue in not.
Actually, you are right.
Domain of appreciation.
In a criminal case, everything has to be decided on the basis of the evidence that is laid before it.
In a given case.
Yes,
in a given
on the basis of the material.
How can there be a straitjacket formula prevailed by this honorable? Anyhow, because there is a reference.
The bench which are
I understand that.
You are also barred from saying that.
You are also barred.
barred from saying that the reference is bad.
What his lordship conveyed to me, what I accepted, may not be known to others.
That's right.
No, but then everybody can guess.
Yes, sir. Yes.
All right.
No, by means of circumstantial evidence.
Yes.
Yes, my lord. My lord, the reference was.
If the accused dies, proceedings abate.
Yes.
The question is whether the complaint dies, whether proceedings abate. That is the question. That is the only question.
Because in the absence of, suppose even if even if it turns hostile, and if there are independent pancha witnesses
Yes.
who prove the trap, court can always draw as to whether their evidence is
Let
trustworthy
us say in this
to
way, my lord.
maintain conviction or not.
True, my lord. I will put it in this way, my lord, for a supplement. My lord, demand is made to defect or complainant. There is his friend is waiting by his side. He is a witness to that. This man dies. He can speak. Based on his evidence, if it is believable, it is trustworthy, my lord, conviction can be recorded.
Can be recorded.
Can be recorded.
He goes and gives a written complaint.
Yes.
There are cases where no action is taken. He goes to the court, files a 482, direction is issued.
Kindly make one thing very clear, my lord. When your lordship is cutting it as a joke or making it to be serious, because we got convicted.
That is
No,
where.
but Mr. Nagmatu, you have, by your experience, after his experience, you know what he is doing.
My lord, I was able to know, but Mr. Patwalia could not. He made a complaint to me.
So you want this question also to be referred to a lawyer?
Because Mr. Patwalia made a complaint that he was not able to understand whether it is a joke or it is a serious comment.
It was deliberate actually. It was deliberately intended to be so.
All right, please proceed.
Yes, my lord.
Give us some factual background.
Yes, my lord.
Otherwise, how will we appreciate it?
Yes,
A bit of factual, only in basic facts. That's all.
You know, basic fact, but in all these cases which are pending for his honor, before the defect of complaint died,
Oh.
there was conviction from out of the other evidences available. So his evidence is not available. Let us put it in this way. Either because of death or because he has turned hostile or he is not available. His evidence is absent. In the absence of his evidence, there were convictions recorded by the trial court, confirmed by the high courts also. That conviction is based on other evidences by way of presumption or by way of circumstantial evidence or from out of the other evidences available. Now, my lord, question is referred to this honorable court. In the absence of, will you kindly look at the question again, my lord. The question whether in the absence of evidence of complainant, to this section, my lord, I got no difficulty. Direct or primary, my lord, how can there be a primary oral evidence? Complainant evidence must be either direct or must be only direct. It can't be primary. Primary evidence is traceable.
Direct.
Primary evidence is relating to documentary evidence. Primary and secondary evidence. In oral evidence, there is only one evidence which is direct. All the other evidences are hit by section 60 as hearsay.
Hearsay evidence.
Hearsay evidence 60. Oral evidence must be direct. Section 59 mandates. If it is a matter to be heard, it should be the evidence of a person who said that yes, I heard. If it is a fact to be seen, it should be the evidence of a person who has seen, not a person who said that I heard it from somebody. So that is so direct. Then, my lord, or primary evidence of demand of illegal gratification. Is it not permissible to draw inferential deduction of culpability of or guilt? There can't be any inference of guilt. There can't be a presumption of guilt. Except section 29 of the Pox Act and similar provisions are there in some other acts. There is no provision in this act enabling the court to presume the guilt. There is nothing. So this is the second part of this question. Then, my lord, public servant under section 7 and section 13(1)(d), read section 13(2). Section 7 and 13(2) are markedly different. You ought to kindly see now, Murad, you ought to kindly come to 7. The reference was because, Murad, 2-3 benches of this court in case of B. Jayaraj and P. Satyanarayana Murthy, the court held that there can't be any conviction in the event the defect of complainant's evidence is not available. In Narsingh Rao's case, another three judgment said that there can be a conviction from what are the other evidences available. This was found to be a conflict between the judgments. So therefore, the reference was made. Anyhow, because the reference is before this honorable court, we are bound to argue the matter. I will explain as to how this can be, the issue can be resolved. We will also kindly consider. Section 7, let us take section 7 first.
Yes.
Whether the offence under section 7 can be proved. Section 7 can be proved in the absence of the evidence of the bribe giver. That's number 1. What is section 7? Section 7, may I read section 7, the old section. Public servant taking gratification other than legal remuneration in respect of official act. Whoever being or expecting to be a public servant, will not may highlight or underline, is expecting to be a public servant because this is not there in section 13(1)(b). 13(1)(d). Accepts or obtains or agrees to accept or attempts to obtain. There are 4 ways by which a person can commit an offence. He can accept illegal gratification. It is an offence under section 7. He can obtain illegal gratification. That is also an offence. Third one, he can simply agree to accept third one. Fourth one, he may make an attempt to obtain, not accept. He may make an attempt to obtain. So the language used is one acceptance, the other one is obtainment. One may accept, one may obtain, one may attempt to obtain or accept to
Agree to accept.
There are 4 things. Now what is to be received, any gratification, etc. Then lastly, what for it is received? As a motive or reward for doing or forbearing to do any official act or to show any favor or disfavor. This is also essential. Mere obtainment, mere acceptance is not sufficient. This
It has to be in relation to that.
Yes, by way of reward or motive, this would have been received. Then only section 7 is made out. Let us now go to section 13(1)(t) under reference. Page 14, you have to find page 14. Now 13(1), a public servant is said to commit the offence of criminal misconduct. But they are not public servant or a person expecting to be a public servant taking gratification. Here, it is misconduct under section 13(1). A public servant is said to commit the offence of criminal misconduct. Let me go to D. If he, one, by corrupt or illegal means, obtains, you have to kindly underline the word obtains, acceptance is not there, obtains for himself or for any other person any valuable thing or pecuniary advantage, or 2, by abusing his position as a public servant, again obtains for himself or for any other person any valuable thing or pecuniary advantage. 3, while holding office as a public servant, obtains for any person any valuable thing or pecuniary advantage without any public servant. So here consciously the legislature has omitted the expression acceptance, accepts. It is omitted here. This is confined only to a case of obtainment, not acceptance. Whereas, as I already pointed out, section 7 includes 4. Obtainment, acceptance, attempt to obtain, agreement to accept. All the 4 are included. Here it is only obtainment. So in a case where there is only obtainment, he can be punished under section 13(1)(d). When there is only an acceptance, he can be punished only under section 7, not under section 13(1)(d). So acceptance and obtainment have got different connotations. They have
No,
got
they overlap, is it? They overlap.
not overlapping. Acceptance and obtainment are different. They have been interpreted by this honorable court.
Then it just comes.
But I have dealt with Malad in my, Dr. May kindly consider, Malad in my written submission. Malad, page 3, you Dr. May kindly come to my written submission. I have extracted Malad in the previous page. What are the essential ingredients for section 7? Accused must be a public servant or expecting to be a public servant. 1. 2. He should accept or obtain or agrees to accept or attempts to obtain. 3. From any person for himself or for any other person. 4. Any gratification other than legal remuneration. 5. As a motive or reward. So these things are to be proved, Murad, so far as section 7. Murad, 13(1)(d), Murad, this provision has been couched in a different language from section 7. A cursory comparison would show that section 13(1)(d) is very narrow, whereas section 7 is wider. In order to prove an offence under section 13(1)(d), the following are to be established. Number 1, the accused must be a public servant. But my note is not expected to be a public servant. 2, by corrupt or illegal means obtains for himself.
Why did you use this? Not expecting to be a public.
It is there not in section 7, not here.
Oh, okay.
It is there in 7.
Yes.
Then by corrupt or illegal means obtains for himself or for any other person any valuable thing or pecuniary advantage. By abusing his position as public servant obtains. Then 4, while holding office as a public servant obtains for any person. So obtainment alone is covered in section 13(1)(d). Now in para 5 I will say, to make out an offence under section 13(1)(d), there is no requirement that the valuable thing or pecuniary advantage should have been received as a motive or reward. Now it is not there in 13(1)(d). Motive or reward must be one of the ingredients in section 7. Here motive, what was the motive for which the money was received? What is the reward? That need not be proved at all here. So far 13(1)(d) is concerned. It is relevant only for section 7. Now, similarly, mere acceptance of any valuable thing or pecuniary advantage is not an offence under this provision. Mere acceptance. Note, mere acceptance is covered by section 7. Then, therefore, to make out an offence under this provision, there has to be actual obtainment. So this is to be proved, Murad, by the prosecution in the absence of the evidence of the defector complainant, the bribe giver. This fact, obtainment is to be proved. Now, since the legislature has used 2 different expressions, namely, obtains or accepts, the difference between these 2 must be noted. Murad, these judgments, Murad, the end, Murad, I will read these judgments. What the judgment say is, Murad, what is obtainment? In both the transactions, whether it is obtainment or acceptance, there is an offer first. In the case of obtainment, the public servant makes an offer. That is demand. He says, you give me 50,000 rupees, I will clear your file. Here, an offer goes from the public servant. The offer is accepted by the bribe giver. He accepts that. Then, in pursuance of that demand, or offer made which was accepted, the bribe giver comes and gives the money that he receives. That I call it as receipt. But in the case of obtainment, I want to repeat, there has to be a demand. That is the offer by the public servant. He should offer, I will do this. You give me 50,000 rupees. This is obtainment. Whereas acceptance is not there. That is the judgment. I will read at the end. I will cite some judgments. Acceptance is, the non-public servant, the bribe giver comes to the public servant. He comes to the office. He says, my file is pending with you. I will give you 50,000 rupees. Please clear. But if you clear, I will give 50,000 rupees. Here, Mullah.
You are very modest, Mr. All right.
The pension matter.
There can be an immediate there can be offer also. Which category it will fall?
That is demand.
Yeah. Yes, yes.
So therefore, my lord, if it is acceptance, my lord, the offer goes from the bribe giver. He goes to the office and says, "You please clear my file. I will give you 50,000 rupees." My lord, there is no demand made by the public servant. The public servant accepts that offer. Then in pursuance of that agreement, he gives the money, he receives it. This is acceptance. My lord. So there is basic difference between acceptance and obtainment is who makes the demand. If the public servant makes the demand, it is obtainment. If the bribe giver makes the demand or offer, it is acceptance. That is the marked difference between section 7 and 13 only. Now, keeping this in our mind, let us go further. Page 5, paragraph 12.
Yes.
If once it is proved that there was demand followed by receipt by the public servant, the act of obtainment in terms of section 13 only is complete. Regarding this statement of law, there may not be a disagreement from the other side. Obtainment is complete when there is a demand and in pursuance of the demand, something is paid and the man receives, public servant receives. But I don't call it as acceptance because acceptance is different. So demand and the receipt, both should be proved in order to prove an offence under section 13(1)(d). So far as section 7 is concerned, there, Murad, if it is a case of acceptance, offer should be proved, receipt should be proved. If it is a case of an agreement to accept, agreement should be proved. If it is a case of attempt to obtain, attempt should be proved. There, so many things are to be proved in section 7, Murad, I will come to that later. Now, Murad, in paragraph 13, I have said, in the case of obtainment, as seen above, receipt of gratification in pursuance of a demand should also be proved as a fact in issue. Now there are two facts in issue, Murad, so far as this is concerned in terms of the Evidence Act. Fact in issue number 1 is whether there was demand. Fact in issue number 2 is whether he received it in pursuance of the demand. Two facts in issue are there. Then, Murad, how obtainment is to be proved? That is the issue now before this honorable court. Murad, obtainment contains two facts in issue. Like in a murder case, Murad, he caused the death, one issue. That was an intentional issue. All these things are facts in issue. But the explanation itself of the Evidence Act. What is fact in issue and what is a relevant fact? Fact in issue, not relevant fact at all for the present. There are two facts in issue. Fact number 1 is whether there was demand. Fact number 2 is whether there was receipt. But if both the facts in issue are proved, then the larger single fact, that is obtainment in terms of section 13(1)(d) is proved. If obtainment is proved, then man is to be necessarily convicted. Now, therefore, Murad, the first fact that there was demand is to be proved. Secondly, the next fact is to be proved. Now, how a fact in issue can be proved, Murad, is the next question. These are all facts in issue. How a fact in issue can be proved? Murad, any fact in issue or even a relevant fact can be proved, Murad, by 4 ways. Number 1, by means of direct eyewitness account. That we call, Murad, as direct evidence in terms of section 59 of the Evidence Act. Direct evidence. Murad, there is a murder, there is an eyewitness, he says that I saw it. Direct evidence is available. Fact is proved. Similarly, Murad, here, he makes a demand. That is a fact in issue. The bribe giver comes to the court and says, yes, he made a demand to me. Murad, direct eyewitness account is available in terms of section 59, that by itself is sufficient to prove, provided his evidence is trustworthy. So, by means of direct eyewitness account, the fact in issue, namely demand, can be proved. By whom? Not this fact can be proved by the oral evidence of the person from whom the demand was made. Now he is no more. So, my lord, by means of his oral evidence, because he is not available, this fact demand cannot be proved. But it doesn't mean, my lord, but the fact of the issue of demand cannot be proved by other evidences. Suppose there is a person standing by his side, as I said sometime before, my lord. He is an eyewitness. He is a direct witness. But he can give evidence in terms of section 59. He can say, when he made demand to the bribe giver, I was present there. He made the demand there. That is enough to convict. That comes under other evidence. But as per a referral order, it is other evidence by means of demand can be proved. So therefore, my humble submission to be the fact that there was a demand made, which is an issue, can be proved by means of oral evidence, provided there is a person who says that I have direct knowledge of that. Be it the bribe giver or anybody else. That's the one way. Now, my lord. Similarly, my lords, the next one. Suppose there was only one person to whom demand was one-to-one affair. Demand was made exclusively to that man. There was no other oral evidence. What if? But the fact cannot be proved by means of oral evidence, that is all. Then we have to go to the next stage. What is the next stage? Next stage is not to see whether there is any documentary evidence to prove. Suppose the demand was made by means of email, by means of letter, by means of some other communication. But those letters, emails and other communications are documentary evidences in terms of section 63 of the Evidence Act. Now that is primary evidence. If the primary evidences are not available, we can lead even secondary evidence. By means of documentary evidence also we can prove the demand. So therefore, the evidence of the bribe giver is not the only source to prove.
Yeah, this is the,
That's not the only source.
yes.
If there is documentary evidence by which also it can be proved. But the question is, in a given case, whether there is any documentary evidence. So case to case we have to decide.
Yes.
Defect of complaint, bribe giver is not there. Whether there is any other oral evidence. Case to case we have to decide. We can't have a straight-jacket formula for that. Similarly, in respect of documentary evidence, in the given case, if there is documentary evidence, if that is believed and if it is found to be sufficient, it can be acted upon. There can be conviction also on that basis. This is regarding documentary evidence, proof of the fact of demand by means of documentary evidence. Then, third method, that is, by means of legal presumption. I have paragraph 7, page 7, you will automatically come to that. Page 7. Proof by legal presumption. Very often this provision is confused in many of the judgments. For what is legal presumption? Let me make myself very clear. One fact is to be proved, a fact and issue is to be proved. But we do not have evidence, direct evidence to prove that. Therefore, we prove a relevant fact, some other fact. On proof of that fact, we presume the proof of the fact and issue. That is fundamentally the presumption. There are three types of presumptions, may presume, shall presume, and conclusive proof. What is may presume? Kindly look at the language used in section 3 of the Evidence Act.
Evidence Act. Evidence.
Because the presumption is available in the absence of the evidence of the defect of complainant. Section 3. Section 3, proof. Section 4, presumption.
Nagamuth, one thing I have found, their act is hardly how many pages, but the commentaries are at least one cartload
3-4 volumes.
of evidence.
But still we have got confusion,
Huh?
Still we have got confusion.
No, that has created confusion. That has created confusion.
Yes.
Those days, not the barracks of
150 years of confusion.
1872, you are right.
Yes. That's section 4. May presume. That's my kindly concern. Whether these things are available in the case, may presume. whenever it is provided by this, with this act, you will kindly underline the word provided. Whenever it is provided by this act, that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, not rebutted, or may call for proof of it. So this is may presume. Murad, here this, Murad, in Vaidyanatha's case, Murad, this honorable court has said it is a presumption, factual presumption. Here, Murad, there is a discretion. The court has to give reasons as to why the court is presuming. A fact is proved, from out of that, whether there can be a presumption that B fact is proved or not. But if the court presumes, yes, B fact is proved, because of proof of A fact, the court has to record reasons as to why the court is presuming so. So this is a factual presumption. It is a logical conclusion arrived by the court. So far as may presume is concerned. Not it only provides, it only enables the court to presume. It is not mandatory. Now we will also kindly come to the next one, Murad, shall presume. Whenever it is directed, Murad, earlier, whenever it is provided, here whenever it is directed by this act, that the court shall presume a fact. Murad, here direction to whom? The statutory direction. Statutory direction is to the court. The court has no option. The court is bound by the statutory direction, legislative direction. Court is bound to presume. Therefore, the language uses shall. Here, Murad, the court need not record any reason. The court may simply say, there is a direction to me. A fact is proved. I hold that B fact is proved. Why? There is a direction. Where? Section 4. It directs me to presume. I need not give any reason. So, Murad, so far as may presume is concerned, the logical conclusion should be arrived at based on the facts. Reasons are to be recorded. So far as this clause is concerned, reason need not be recorded. Court will simply say that I am bound by the direction. Therefore, I hold that this fact is proved. But C, you will not kindly see, conclusive proof. This is also a presumption. When one fact is declared by this act to be conclusive, but declared, provided, directed, declared. Here, Murad, the court has got no work at all. First thing, some labor to come to a logical conclusion. Second one, court has to say, yes, I presume. That is the job of the judge. I presume. Why? There is a direction. Here, he need not say anything because there is a declaration. Yeah. 112 Murad of the Evidence Act is the classic example for that. Conclusive proof. Presumption of paternity, legitimacy. 112. Now, Murad, for keeping this Murad in view, let us go, Murad, to the issue in our case as to whether there can be a presumption in this case. Because this is because de facto complaint is happening.
Presumption in what sense? Because he is dead now or there is no evidence.
Yes.
So presumption of what?
Presumption of demand. Presumption of receipt. Oh. Whether these two can be presumed so as to prove obtainment.
Okay.
Whether these two things, Murad, can be presumed. Now, is there any enabling provision to presume? That's the point. Now, Murad, very often, Section 20 of the Prevention of Corruption Act is relied on by the courts. You will not kindly have you look into Section 20, whether this will help us, Murad, to prove demand or receipt. That is, in other words, obtainment. Murad, the old provision, Murad?
Yes, we have.
Bottom. Presumption where public servant accept the gratification other than legal remuneration. Where in any trial of an offence.
Referring to?
20 minutes, section 20, old provision. Minutes.
Page 22.
Page 22 minutes.
Yes.
Section 20 minutes. Where in any trial of an offence punishable under section 7, section 11, or clause A or clause B of subsection 1 of section 13(1). 1 of section 13. It is proved that an accused person has accepted or obtained. But accepted is there, obtained is there, or has agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal remuneration or any valuable thing for any person, it shall be presumed. What shall be presumed? It shall be presumed unless the contrary is proved that he has accepted, obtained, or agreed to accept, or attempted to obtain that gratification or valuable thing, as the case may be, as a motive or reward. But what can be presumed is that it was accepted or received, obtained only as a motive or reward. But that is the only presumption that is possible under Section 7, nothing more. But the presumption of obtainment is not possible under Section 7 because Section 13(1)(d) is not included in this section. Not kindly consider. 13(1)(d) is not there. It contains Section 7, 13(1)(a) and 13(1)(b) alone. 13(1)(d) is not there. 13(1)(d) speaks of obtainment. Therefore, my lord, in order to prove obtainment for the purpose of Section 13(1)(d), Section 20 presumption is not available at all. It is available for Section 7, not for 13(1)(d), conscious omission. Therefore, my lord, by invoking, there is, in effect, my lord, there is no provision in this Act either providing or directing the court to presume something. There is no provision. Now, under Section 20, what shall be presumed? It is only a reward, motive or reward alone can be presumed. That is relevant for Section 7. I report to Section 7. Apart from attainment, apart from acceptance, apart from agreement, apart from attempt, one more fact and issue is to prove, that is, it was received as a motive or reward. So motive or reward cannot be proved easily. Therefore, they have made a legal presumption under Section 7 enabling the court to presume that it was received towards motive or as a reward. That is the only presumption. But at any rate, this presumption is not applicable to Section 13(1)(d). So, therefore, there is no legal presumption provided under this Act to presume obtainment for the purpose of Section 13(1)(d). That is also gone. Now, what remains further? Whether presumption under Section 114 of the Evidence Act can be used.
Adverse inference.
114, yes. You kindly have a quick look into Section 114. But under this statute, I have made it very clear that there is no legal presumption provided. 114, which is a general provision which is applicable, which is not excluded. Now, when it can be presumed, the court may presume. Kindly consider it is may presume. It is only law has provided for presumption. Logical conclusion. Well, it is not shall presume. It is not shall presume. It may presume. First part which I read under Section 4 of the Evidence Act. The court may presume the existence of any fact which it thinks likely to have happened, regard being heard to the common course of natural events or human conduct and public and private business. We are concerned with the human conduct. Not from out of the natural human conduct of an individual, whether in a given case, the fact of obtainment, namely when a demand as well as acceptance can be proved, cannot be decided by means of straitjacket formula. But in a given case, from out of all the other evidences, circumstantial evidences, it may be possible to presume, in a given case, it may be possible to presume that this man would have received the money only after demand. That presumption is available under Section 114. But this kind of presumption cannot be heard in vacuum. This requires lot of foundational facts which have to be proved.
Yes.
For example, to make myself clear, I will say, Section 114, A, illustration A, you ought to kindly consider. This relates to human conduct. the court may presume that a man who is in possession of a stolen goods, soon after the theft, is either a thief or he has received the goods, knowing them to be stolen, unless he can account for his possession. Now, what are the foundational facts which are to be proved to presume that he has committed the theft? Foundational fact number one must be that there was theft. That should be proved. The owner of the house should come and say that there was theft in my house and these jewels were stolen away. He should say that. There has to be proof of theft, number one. Number two, my lords, the properties must have been found in the possession of the accused. Second fact, which should be proved. Third one, the properties which are found in possession of the accused are the stolen properties. Third fact, which is to be proved. Fourth one, when it was found in his possession, soon after the commission of the theft. If these foundational facts are proved, my lords, then before presuming, we will call upon the accused to give any explanation for this. Suppose he gives an explanation. I was just walking, it was found lying there, I took it. By the time I was taking, you came and captured me. He says, if that explanation is accepted, the presumption cannot be raised. So therefore, Murad, a presumption under section 114 can be raised only on proof of certain foundational facts. Without those foundational facts, Murad, there can't be any presumption under section 114. Now, what are the foundational facts? Can we have a formula? No. Murad, in a case, in a thefty case, these are the foundational facts. Let us take the case of dowry death. Murad 304B. Murad section 113, 114A of the Evidence Act. Murad, what are the foundational facts? There was marriage. Death was occurred within 7 years of marriage. Death was unnatural. There was a demand or harassment in connection with the dowry, in connection with the marriage, soon before her death. If these foundational facts are proved or not, there can be a presumption that dowry death was caused by this husband. In the absence of proof of these foundational facts, we cannot presume that there was dowry death in vacuum. So similarly, Murad, here in our case, the fact the bribe giver is no more. There is no documentary evidence. There is no other evidence. Section 20 is not applicable. There is no other evidence even to presume under section 114. But in such an event, the accused is to be acquitted because attainment cannot be proved. Can we say, my lords, that these are all the foundational facts which are to be proved to presume under section 114? No, we can't say. It all depends upon facts and circumstances of each case. So one thing we can say is that the presumption under section 114 is very much available provided the foundational facts are proved. So this is regarding section 114, presently one way of proving this obtainment, which contains two facts, demand and receipt.
But it
Done,
is a
Lord.
rebuttable. It is a rebuttable presumption.
It is rebuttable.
Only foundational facts lead to a presumption,
Yes.
but it is rebuttable.
Yes, madam, it is presumption. Section 4 itself makes it very clear. May presume as well as shall presume are rebuttable.
But
How to rebut, that may not be within the scope of this reference, therefore I am not saying. Rebuttal need not be by means of proof beyond reasonable doubt. In order to presume, the foundational facts are to be proved beyond reasonable doubt. Woolmington principle is applicable. If once every foundational fact is proved beyond reasonable doubt, then court logically presume this fact. After presuming, the court will call upon the accused to rebut. That rebuttal need not be by means of by proof beyond reasonable doubt. It is enough that it is done by means of preponderance of probabilities. In Vaidyanatha year's case, this honorable court is held. So far as may presume is concerned, if suppose the court presumes, rebuttal can be only maybe by means of mere explanation. Mere explanation. Suppose the accused gives an explanation under section 313 CRPs, and if that explanation is plausible,
Election.
Oh,
Correct? Flag day.
yes. Flag day correction.
But Nagamuthu, who gives explanation nowadays? Everything is denied. Everything is a denial
Your
nowadays.
lordships asked me, my lords, when I defending, what is your explanation?
Generally nowadays, nobody takes this type of stand in criminal case. Everybody depends upon proof.
Total denial.
Total denial.
No
They
explanation.
deny the relationship of father and mother also.
So the explanation is must, my lord.
Yeah.
If it is may presume, it is enough, my lord, that a rebuttal can be by means of plausible explanation. No evidence need be let in. Mere explanation is enough. If it is shall presume, because it is a statutory direction to the court to presume, because it is called a legal presumption, but this rebuttal of this presumption can be made only by means of evidence. You not kindly consider that. But it can be done by means of evidence. So far as Provincial Correction Act is concerned, my lords, it is shall presume, not may presume. Under section 20, it is shall presume. In order to rebut that, my lord, there has to be evidence let in. Either it need not be the defense evidence. From out of the evidence of the prosecuting witness during a cross-examination, something can be collected, which can be used, my lord, to support the explanation. So to support the explanation, some evidence must be available on record. Then only, my lord, there will be rebuttal. Otherwise, there won't be any rebuttal, my lord, so far as the shall presume is concerned. My lord, in this case, my lord, in a given case, we have to see whether it is possible to presume demand and also the receipt of illegal gratification by the public servant. Presume. But there is, as I already pointed out, section 20 is not helpful. Section 114 to invoke, there are two foundational facts. In no case, in my experience, there are such foundational facts produced in court. Therefore, practically it is impossible. That's what I am saying. Practically, in all these cases, if we make a survey, there can't be any possibility for presumption under section 114 because foundational facts are never collected during investigation. They rely only on the defect of complainant. They pray to God Almighty that he should be alive till the trial is over. They don't go into the other evidences available. Like to presume. So this is by way of presumption. By way of presumption also, it can be proved. Now, demand, if proved, that by itself is not sufficient to convict him, demand 13 only. They have to prove not the receipt. In pursuance of the demand, there was a demand which is offered, he accepted, he came and gave the money. The receipt should also be proved. This is the second fact and issue, which should also be proved. How this fact can be proved? Now, my lords, the person who gave the bribe, who is common to both, demand was made to him, he gives the money. He can depose, his evidence is direct. If his evidence is not available, through other evidences, Murad, the receipt can be proved. Receipt can be proved. Let us assume, Murad, that during trial proceeding, the man Murad goes and gives the money along with the accompanying witness. The man is now no more. There is no proof of demand, but there is a proof of receipt now, because the accompanying witness will say that there was a receipt. But in the absence of demand, mere receipt would not back out an offence under section 13 only. Very simple.
Yes.
Both are required. Mere receipt is not sufficient. So therefore, Murad, in a case where when it is too well settled, there are a number of judgments Murad, I also cited. In the absence of demand, mere receipt would not back out an offence under section 13 only. It is too well settled. I need not go into that. I cited a number of judgments. Therefore, Murad, my humble submission in respect of receipt is concerned, assuming that the receipt is also as a fact and issue to be proved, either by means of direct evidence, or by means of documentary evidence, or by means of legal presumption under section 114. But assuming that by any one of these methods, this is proved. Mostly, in cases, there is an accompanying witness who never turns hostile, and he will give evidence that I was present. He went there, he gave the money, he received. So receipt is proof. That by itself is not sufficient to prove an offence under section 31D of the Act. So because what is required is proof of demand as well as the receipts. Both are absent. So now, Mullets, so far as 13(1)(d) is concerned, my argument is this, Mullat, my submission is this. Two things are essential. There are other facts and issues, Mullat, whether it is a gratification, illegal gratification, all these things. I am not going to all those ingredients. Main ingredients are two. One, demand, the other one, receipt. In the absence of the evidence of the defect or complaint, the bribe giver, how to prove these things? Mullat, I have explained. It is very difficult. Mullat, for that we cannot have only a straightjacket formula. In this case it is proved, in this case it cannot. We cannot say that. It all depends upon the facts and circumstances each case. But broadly, Mullat, these are all the ways, Mullat, in which it can be proved.
Adbhutu, one thing,
Yes, Mullat.
you are appearing for the accused.
Yes, Mullat.
The reference is on the death of a complainant, whether the proceedings come to an end or abate or
Not come to an end, Mullat. Can there be an inferential deduction? Understand that?
So, all right.
Inferential
So
deduction.
what you are saying, it is possible through inferences.
It is possible, Mullat. That's wrongly
But you are
stated.
appealing for the accused.
Maybe, Mullat, I cannot state the law wrongly when this is question is being decided by the constitution.
What is there? Who is opposing you then?
Mullat, in my case, it is not there. That is the point. In
Factual.
my case, demand cannot be proved in the absence of the defect or complaint. There is
Somebody should oppose this proposition. She will definitely agree with you in all these aspects.
If she agrees, Mullat, there is no issue.
No, what you are not trying to say is, on law,
This is the
this
position.
is the position. On facts, I am entitled to acquittal.
In my case, reason is, Mullat, there is no direct
That
evidence.
won't be decided by us.
Learned ASG has nothing to argue then.
Mullat, I cannot wrongly state a law, Mullat. Can I argue against the evidence act?
But somebody should assist us from the other side also. It is possible, somebody should tell us for reasons 1, 2, 3, 4, 5, even on the death of a complainant, the proceeding should go. Somebody should argue like that.
It should go, Mullat. It should go. It is my
No. You said by inferences, by adverse inference, etc. You can still.
proceeding should go means wipe off. No, I say, Mullat, proceeding will go further.
Proceedings will proceed.
Yes.
Go on, go
Go
on.
on, go on.
Go further.
I said go means going.
No,
Not-
it won't go, Mullat. It won't go. It won't go. No, I cannot.
See, you said there are judgments this side, that side.
Yes,
No. Today it's not possible. You take us through the judgments on both the sides.
yes, Mullat.
Huh?
Yes, Mullat.
We'll continue, brother.
So in these four methods which you said,
My lord.
this proof by other evidence is the fourth method.
Yeah,
Four
fourth
methods.
one, circumstantial evidence. But I will.
Such a manner that 7, 13, 1D, 13, 2, everything is clubbed together.
7 and
This
13 D.
question referred, no.
13 on D alone.
Oh. Read with section 13.2.
13.2 also.
13.2 also.
13.
Talks about 13.2.
Get with punished.
No, therefore,
13 on the
the
definition class
the question mixes up all. And let's talk only about demand.
regarding the
But in
question.
fact, there is a further reference also by His Lordship, Justice Ramanna's bench also. If your Lordship has that, that's another reference. That's
No. There is no reference. All that he says is, in fact, the 3-member bench
Yes.
reference. It says when the primary evidence of the complainant is unavailable.
Yeah.
That means the bench has presumed that the evidence, the oral evidence of the complainant is a
Primary evidence. Latma, one more minute may I take. One more. Latma, kindly take my written submission. Let's paragraph at page 15. Page 15 minutes.
Yes.
Paragraph 41.
You want the question to be reframed.
But I will. But I will
Correct or not?
But may I read it for my benefit. With the great respect, it is humbly submitted that the issue as framed has more than one defect. And
So
therefore,
that should be answered first.
And therefore, the issue needs to be reframed accordingly, then it may be answered, my lord. What are the defects?
But suppose the question is strongly framed, therefore no answer.
No answer. Well, what are the defects I have said? Well, defect number one.
We can
All right, let us see. We'll meet.
Lords, your lordships asked for judgments. We made two compilations.
You
I'll
pass.
share with my colleagues.
You pass on.
These two compilations we have compiled, my lords. First is, my lords, understanding the PC Act, and second we made three categories. One where complainant died, one where he was hostile, or one where he was not declared hostile but found to be not corroborated, found to be not trustworthy, and therefore needed corroborated. So these judgments might help.
No, that comes within the domain of appreciation.
But, my lords, these
Evidence-
judgments-
Those are the judgments, you know. Let us.
No,
Please
no,
just hand
those
over.
issues are not before this honorable court. But is complainant, the issue is in respect of a case where there is no evidence of the complainant. But if the complainant is available, he supports the case. But whether his evidence requires corroboration on the petitioner demand or not is a different issue. That is not there before us. It falls within the domain. In a given case, court may say, yes, the solitary evidence is sufficient. In another case, court may say, no, it is not sufficient. We require corroboration. How can we have settled?
You wanted to say something?
502.7 million.
Huh?
502.7 million. And matter has been tagged with the main matter million. No notice has been issued million. Your lordship may issue notice.
All right, we issue notice.
I will serve the state of Andhra Pradesh.
Permitted to serve the council for Andhra Pradesh.
So is it connected with the
502.
502.7.
2.7 miles.
Then what is it? State of Karnataka, all right. So you serve Raghupati, give it to Raghupati.
notice, they tag it.
Notice permitted to serve.
I will be appearing in 502.6 million. I will take in different line on my learned friend's argument.
Oh, so there is one opposition at least. All right, all right, Mr. J. All right. All right.
According to you, the word primary must be read as direct.
Primary evidence relates to documentary
Documents.
evidence, not oral evidence, but the question
Primary
is wrong.
means direct.
Direct evidence not relating to oral evidence.
Yes.
Direct, as per section 59. But primary, as per 63, relates only to documentary evidence. But the referral order says it is also the oral evidence.
All right, we will meet.
Grateful.